You don't go to Supreme Court saying that High Court had granted, it is violated. You approach the authority whose order is violated. We will
Whereas the deceased employee was employee of the LIC Lordships.
we will protect your possession for 1 week. File an appeal.
Lordships, the WP, the same for the same matter, another WP is pending Lordships.
We are
until
concerned
the
with this.
disposal of that the WP Lordships. Because the terminal death benefits also has not been received by the petitioner.
So that you will get it in that writ petition. That doesn't mean that you will not take recourse to statutory remedy provided under law. Understand, we can have sympathy for you that, and we can, you urge that get it that petition decided for terminal benefit. That doesn't mean that you will not take recourse to, we can't violate the law.
Lordship, that is not for terminal benefits, Lordship. That petition is filed for the compassionate appointment.
All right, anything else?
Till the disposal of that, because it is filed in 2021 Lordships.
There is a judgment of Supreme Court which some council has given, cited. We have
Sir,
written also.
Yes. Humble request, Lordship, the citizen widow and having two sons, one of the son is transgender.
Fine.
So they are very poor, Lordship.
Fine. Yes, madam. Learned counsel for the, in this, Mr. So-and-so heard on the question of admission. In this writ petition, comma, the petitioner has assailed the validity of the order dated
Lordships,
Which judge? Yes. So, interim order passed by DRT is violated, so remedy is writ petition. Should you not approach DRT?
yeah, interim order has been given by the DRT.
If it is violated, then whom should you approach?
The
The
appellant,
person, see, mister, if we grant an interim order in your favor, simple thing, you understand all this time wasting tactics. If we grant an interim order and it is violated by the state government, GP revenue, you don't go to Supreme Court saying that High Court had granted, it is violated. You approach the authority whose order is violated. Simple.
the same may be directed,
Not
Lordship.
directed. You withdraw with the liberty, otherwise we will
No, no.
dismiss. We cannot entertain the writ petition for
I also-
violation of an interim order passed by debt recovery
I
tribunal.
also filed an application seeking before this, my lordship, seeking for a direction where the property was being belongings of the tenants were being seized on the same day, on 31/7/2023. In spite of the orders were been sent.
Your remedy is, mister, we are not sitting here to advise you. A very good thing, file a writ petition, ask the opinion of the court and then say that the court has directed me to approach DRT. Huh? It's not, we will dismiss it.
At least a direction may be passed, lordship,
Nothing,
for the belongings that were been
no,
seized by, by the advocate commissioner,
no. No,
by the
belong-
respondent but two.
Whatever you are urging
Okay,
here, you
this-
can urge before the
this-
DRT, saying that the attachment is only in respect of the movables. I have attached my immovables.
Heard on the,
To take out my immovables,
heard on the question.
whatever it is.
Heard on the question of admission. In this writ petition, comma, the petitioner inter alia has sought a declaration. What did, sought a writ of man, how they wrote, right, we don't know. We are going to ask you one question someday. Mandamus, how does it write for inaction? You all have read mandamus, writ of mandamus in your LLB courses and every day thereafter. C has sought a writ of mandamus or direction declaring the action of bank in not considering request for breach of order dated 9/8/20, order dated what?
31/7,
Order passed in SA number, you don't give the date also.
31/7.
31/7/2022 passed in SA number 314/2023. Paragraph after hearing the counsel for the petitioner at length, comma, we are of the considered opinion that the grievance of the after hearing the learned counsel for the petitioner at great length, at length, it is evident that the grievance of the petitioner in this writ petition is with regard to violation of interim order dated 31/7/2023 passed by the debt recovery tribunal.
Please, your lordship.
Heard on the question of admission, petition is admitted for hearing. Yes. Notice. Yes.
Your lordship, small submission.
Heard on the question of admission, petition is admitted for hearing. Item
Connected matter, Your Lordship.
7, no?
Connected matter listed on 6th September. So item 6, Your Lordship. Item 6, connected matters listed on
This
6.
along with WP. Then nothing is going to happen. This is
Your lordship,
admitted
small
for hearing.
submission, your lordship.
Yes.
With respect to item number 5. Lordship, I may permitted to take out personal notice on the 7th respondent counsel, your lordships.
5,
Your Lordship.
So six, Mr. What five?
Item number 5.
Admit. Admit notice, personal notice, yes, that is always there.
No, Your Lordship.
Personal notice and proof of service, that without saying.
No, Your Lordships. I'm saying, Your Lordship. I'm saying that.
No, we should hear you for half an hour, right?
No, only one
Please
second.
call, madam.
Petitioner's
Which number,
counsel, Your Lordship.
item number? Which item, Mister?
Item number 5, Your Lordships.
He says five.
I'm seeking a permission from the Honorable Court to take up personal notice on the respondent's counsel.
No, that business we don't engage in. No,
Council not
sorry.
take off.
Prayer for service of notice on counsel for respondents is rejected. Yes. Every little thing you want rejection, right?
No, not rejection is not required, Your Lordships.
No, the problem is if we dismiss the petition, there is a problem. If we admit, then also there is
No.
problem.
Directly. Depublize, Your Lordships.
Ah. What? All backdoor entrants like Uma Devi, what regularization, Mr. How have you got it into the service? Sanction posts are there? Not there.
Your Lordship, kindly see,
Were you subjected to process of selection?
2005 through proper channel.
Huh?
Through proper channel.
Proper channel
Proper channel.
against sanctioned post.
Point. Your Lordship,
Admit.
kindly see the 105 for a movement, Your Lordship.
Admit notice.
But Your Lordship, in this matter, this court has recommended for regulation, Your Lordship, to the government.
Regularization of services or persons appointment. Government may
Which is, madam, which case this?
This is 7.
Admit.
May regularize.
Give that file 7. The issue involved, the petitioners are contract employees of judicial department. In this writ petition, the petitioner seek regularization of their
Your Lordship, this court recommended to the government to regularize the services. Even
That
despite
is
of
the
the
pending consideration before the Honorable Supreme Court.
problem.
it is for admission. You want it to be disposed of, right? Without notice to them, and you want that they should go to Supreme Court and seek stay. That without hearing us, an order has been passed. What is this, Mr.? Others are waiting, Mr. These are all matters which we ourselves are, despite that you are interested in wasting time of the court. Yes. Okay. What is the evidence, Mr.?
Letter.
That it is this thing scheduled land.
Schedule. This the writ appeal is filed against the order.
No, that is all done.
Yeah.
We know we will dictate the order. We are answer only the query why it is this thing. Why, how does it falls within notified agency area?
Yes, my lord. This area.
Which notification, where is that?
Yes. 11.
There is a finding, right?
My lord, in the
Page
latest.
15.
My lord,
Read page 15 if you have not read it here.
Yes, I read.
Today.
I read.
You read it
Now,
today. If you have not read the
Yes.
file at home, read
No, my lord, I read it. On the basis of the
page 15.
15, I am reading, my lord. This interim order is continued by order dated 4/6.
No. Having regard to.
Having regard to the same, in the absence of any record to the show that the land falling in the Mangapeta Mandal are included in the notified agency area. The stand taken by the official respondent that based on the communication received from the director, the subject lands are treated as if falling in the agency area is without any legal basis. In the absence of any notification issued by the government of India, notifying that the subject lands are falling in agency area, the communication cannot be the basis for saying that the subject lands are falling in the agency area. The relates, yes,
One second. Earlier, if you see 1950 order, all villages of Paloncha Taluk of Warangal district excluding Paloncha, Burgumpad, Ashwarapet, Dhammapet, Kukunur and Nelapak villages and 2 is Samsan of Paloncha are excluded.
yes,
Merely because these villages now are taken out from Paloncha and are included in Mulugu, They do not lose their status of a scheduled area.
That's true. By reorganization of the districts, or by the, that's true. But this was, this matter,
No, no,
is then
Mr.
covered by, this matter. here-
1 minute. What is the material to show that simple? This village is within the scheduled area, notified agency area. Tell us.
Will at this matter in respect subject to your lordship.
Yes.
These 23 villages, whether they fall within the scheduled area or not, extensively dealt with by this honorable court. My lord, this, your lordship may kindly say, extensively dealt with. This,
No, no, it falls or not. What is the material?
my lord, on the basis of the material only, my lord. On
The learned single judge has recorded a finding that you did not place
Yes,
any
that is
material.
what, my lord, learned
Did you
single
file
judge-
this before learned single judge?
Just a minute. Just I should dispel doubts. Learned single judge, on the basis of an interim direction granted by this honorable court, in a matter pending before the division bench, this order came to be passed by the learned single judge. Learned single judge, in the same order, referred to an
So
interim.
then what is the final order?
Final-
Come faster, Mr. We are perhaps quick then, you realize.
I'm coming to the
So
final.
then you say that interim order, then what final order? You are not telling us.
Final order came to be passed by this division bench, holding that these 23 villages fall within the schedule area. This
Where is-
final order,
Which paragraph?
yes, Melody, now, your lordship may kindly come to para numbers 18,
Which?
page number 27, para 18, had extensively dealt with this issue. Melody, let single judge has considered this aspect in proper perspective and after correlating the Government of India Act 1935 and regulations made.
Which village? Where is the finding that Mangapet village is in?
Yes, Millet, in 23 villages, Millet,
Where is it?
Millet, the para at 7 Millet, para 7 at page number 4. The lordship may guide. In the division bench form, page number 4 Millet.
Only on admission. Mr. Additional Advocate General, you are only arguing on admission, not final hearing. Heard on the question of admission.
Exactly, I have answered.
Exactly, no. So therefore, within 1 minute, you should conclude that, sir, this village has been held to be
Division bench of
falling
this
under by division bench of this court. One sentence is enough.
That's what I was
You
about
are
to say.
saying that I am coming.
I was about to say that only Millet, your lordship directed me to read paragraph so and so that's why I have to follow what your lordship
No,
says.
no,
Millet.
not follow. We thought that perhaps you have not gone through it.
I
That's
thought-
why we said that
Millet,
please read it.
before
That
let-
single, you should, what two sentences additional Advocate General? Learned single judge has held that there is no material to hold that this thing is in notified area or whatever agency area. The division bench in para 15 says it is within agency area.
Yeah.
That's it. Two sentence.
Millet,
Huh?
yes.
This art of brevity heard on the
Malad, before passing order, I'm appearing for the unofficial
not
respondents.
passing any order,
Admitting.
admitting.
So, obliged.
You have filed the KVA.
Yes, well, in fact, I filed wakalat for Malad respondents one to
KVA?
three. Keep I'm sorry, Malad, I have never. Obliged.
Don't, I mean, advance copy does not authorize you to oppose admission until unless he is making factually incorrect submission.
Obliged.
We have to, why we are hurrying up, mister? We are seeing the faces of MBBS NEET aspirants, their results, and they are seeking admission. That is why. Otherwise, we can hear you. He could have argued for half an hour. You could have replied for till 1:30. We would have been very happy. Thereafter, at 1:30, passing an order admitted for hearing.
While filing writ
They
of
would have
appeal,
been over.
filing writ of appeal, the council on the requisition is served the notices, Malad. That is the procedure, according to lordship's notice.
We are trying to.
So that is why I'm Malad before the lordship's notice, otherwise.
One minute. What we are trying to tell you is our approach, because you may feel no why the court in a hurry. We are in a hurry because there is a bunch of MBBS students seeking admission. It is to be heard today. So therefore in a hurry, otherwise we would have heard you leisurely. That's what we are saying.
I leave it to Lordship. So wait, Muller, just.
Heard on the, and this is admission, your not your appeal. His appeal, admission between him and court. Heard on the question of admission. Appeal, this intra-court appeal has been filed.
Move an application for fixing an earlier date, will.
Learned counsel for respondent may file counter to IA 2 of 23 within 3 weeks. Yes.
Obliged.
Yes, madam. Ah,
May I please, Your Lordship, sir. Let I am appearing for the contempt of let.
contemner of appellant. Ah,
Let
So-
me,
Proceeding on the same basis, he again
asked him.
Mr. Sanjeev, last
Right.
time we told you that unless until fresh material, not on the same charges, you cannot initiate fresh proceedings.
may I make one submission, Your Lordship, may kindly see, now that it is complied with, I'll show it to Your Lordship's.
No, no,
Not
but you-
complied with.
At the order of the learned single judge, it is at page 41, para 7, Your Lordship, may kindly see.
No.
Page
So
41.
only after punishment in contempt you will comply.
Let even prior to that, there is I'll just make one submission, quickly.
No, no, Mister, as we understand, we'll tell you, we are trying to save time today
Correct.
because of medical students,
yes.
right? We are trying to tell you is that this appeal is under section 19 of Contempt
Yes,
of
ma'am.
Courts Act
Yes, ma'am.
against order by which you have been, you have been held responsible.
But there is-
Contempt and a fine of rupees 20,000 has been imposed on
Yes.
you. So your submission is that it has been complied with.
But it has,
So that does not mean that you did not disobey it. Learned single judge has directed in a writ petition 18611 that the order of compulsory retirement be set aside
yes, ma'am.
and petitioner be directed to be reinstated in
Yes.
service and to pay 9 months salary to him.
Yes, we have paid, my lord, even
Just a
before.
minute, just a minute. The learned single judge has said that thereafter you have reinitiated the DE on same charges, this thing. So that has been held to be willful disobedience and 20,000 rupees fine.
Let,
So how is it, have you withdrawn this reinitiation of DE on the same ground?
let the learned single judge said that let the complaint copy is not furnished to him. Millet, there was no complaint, Millet, was the impression Millet gathered. Millet, there was a complaint, Millet, complaint has been given to him.
No. What is your case in appeal? You did not reinitiate the DE against
We
him?
have reinstated because there is a liberty granted by the learned single judge to reinstate. Page 47, page 41, para 7, Millet, that is the reason. Millet, I'll,
No. 1 minute. 16/8/2022 direction was passed
yes, ma'am.
by learned single judge.
Yes, ma'am.
When have you reinstated?
Millet, we have reinstated, Millet, on 21/9/2022.
1 minute.
28/6.
1 month. 1 minute. This order is 5th June 23. So you have reinstated when?
21/9/2022, Millet, reinstated.
20.
21/9/2022, Millet,
And
reinstated.
salary.
Salary has been paid, Millet, on 28/6/2023.
Milord, I contradict this.
1 minute.
Yes.
Court is with you. I mean, we will come back to you after. Yes.
Thank you.
Millet, the direction is threefold, Millet. First direction is to reinstate. That has been done, Millet.
Pay the salary.
This pay the salary is also, Millet, complied with. Millet, there is a finding by the learned single judge that salary has also been paid in the contempt order, Millet. Page 11, Millet, 2 lines, Millet, I read. Page 11, Millet. Page 11.
Yes.
First line, Millet. Having para 4, having regard to the rival contentions, this court finds that one of the direction of this court payment of salary after being reinstated into service has been complied with by the respondents. However, with regard to Millet, the furnishing of the complaint copy, Millet, that was not done, Millet, inadvertently. Now, Millet, it has been supplied. I have filed the material paper. The contempt was also initiated only for non-payment of, Millet, the wages.
So your case is not a willful disobedience.
Yes.
First sentence.
Millet, the
Milord, they are simply wasting the time of the Honorable High Court, Milord. Kindly see, Milord, 18/6/11 of 2022 orders, Milord. They were challenged in contempt case, Milord. In page number 32 to 42, it is clearly written, Milord, that there are 3 parts.
Please go to para 7, read 4 lines.
Yes,
Para 7 now at page 41,
yes, Milord.
read 4 lines.
Milord, direct the respondent to reinstate the petition.
However, 4th line.
However, liberty is also given, Milord.
Yes. But read.
The ending lines, Milord, that
Please read. Liberty is also given.
liberty is also given to the respondents to take action in accordance with law by providing reasonable opportunity to the petitioner if there are any complaints against the petitioner. Milord, that complaints against the
So this
petitioner.
interpretation is it should be a new complaint, not the old complaint.
Yes, Milord.
That is what we understand.
Yes, Milord.
All right. Yes. Anything else? Anything else?
Milord, they have clearly disobeyed the order.
Fine.
Obviously.
This appeal under section 19 of the Contempt of Courts Act 1971 has been
They say that they have apologized, but they never apologized.
He was present physically and he has submitted.
You should
Milord,
have
he was
said in
not-
your counter.
He was summoned.
You have said in the counter.
That counsel
So
was fine.
council has, madam, council has tendered an unconditional apology.
Yes.
No, Milord, they have not.
No, we have, even if Mr. Nothing turns upon apology, it's a case of our contempt, right? The court's contempt. We have held there is no value, this thing. You have got it right, everything, salary restatement.
Okay.
You don't get the immunity that I will commit misconduct and nobody can inquire. Yes.
No, Milord.
Great.
Yes. We have given enough time to your case, madam. We don't have a time today.
Yes, Your
record.
Lordship, sir. Today it's for production of records, Your Lordships.
What happened to the record?
Record.
Mr. Sanjeev,
Milord, I have just now received Milord, the record. Milord, your lordship kindly accommodate me Milord, to any shorter date. Milord.
Yeah. Yeah. When tell us. Learned a special government leader submits that the original record in a sealed cover in compliance of the order dated 4/8/2023 shall be produced before this court positively on 30th
In
August,
this week, Your Lordship.
30th August 2023.
I'll file it
Your
along
lordship.
with a memo. Milord. I have received it.
Sealed cover, we have said,
Sealed cover, Milord, I'll submit it. I have received it in the morning. Milord. I'll file it.
a sealed cover,
Very
placed on 30th August 20.
May I request this, Your Lordships, because of the fact of the urgency in the matter?
No urgency, no greater urgency than seeking admission to MBBS seat.
Your Lordship,
Council-
I understand. 30th
He
August.
He is entitled to compensation.
Yes,
That-
yes, Your
Which
Lordship.
will be determined depending upon the
On
record of
the
30th.
manufacturing aspect of it. Yes,
He's, in any case, he's praying for time today. Otherwise, we would have heard you sitting by 8:30 in the
Your
night.
Lordship's not.
Madam,
Great.
yes. You wanted adjournment in the morning, right?
Yes,
We have stopped this practice for good. That otherwise your council would have said that,
the senior
you
counsel,
cannot be permitted to construct this thing of boundary wall on a public road.
All right.
Yes. What?
the senior counsel is appearing in this matter, not due to his personal.
Yesterday, you are Mr. Bhaskar Reddy,
Yes,
right?
yes.
Yesterday also, last date also adjournment to go through the same, again adjournment.
Our last
You are
week,
mastering the art of adjournment.
no, Milord.
No, some councils in Karnataka, junior ones, they are writing a book on law of adjournment. I will share their number with you. You can contribute another, all grounds are being updated on law of adjournments.
I ensure that no further adjournments will be taken, Milord, especially in this matter. Milord.
Learned counsel for the appellant once again prays for adjournment to enable him to prepare the case and argue the same list after 4 weeks.
Obliged.
Next date, it won't be adjourned.
May it please my lordships. Lordships, may kindly
You
permit
have
me.
got certificate
14%,
from
my lord.
13% committee, right?
Yes, my lordship.
Ah.
I've cleared the
Fine, yes.
index.
Ah.
My lordships may be pleased to allow me to file a synopsis and.
No,
documents.
nothing. You argue on admission,
Yes, my lords.
5 minutes. Yes.
All right, lords. My lords, this is against the impugned order of the learned single judge, wherein like we have made a complaint to the State Medical Council against two private respondent doctors, my lord. They are attached with the respondent number 1 in the government service, my lord.
Yes. Yes.
My lords, they are involved in multiple heinous crimes like culpable homicide not amounting to murder, 304 part 1.
1 second.
Yes, ma'am.
Question to you is, does the state medical board doesn't have the power to look into medical negligence? If
No,
medical negligence is there,
My lord, this is not a case of medical negligence, my lord. This is a case of administrating medicine with the intention of false motives. It has an issue of criminal element
no,
involved.
we have gone to
One and the
state.
same thing, one and the same thing, medical
On humble
negligence.
submission, my lords.
Criminal means he should go lodge FIR. But
My lord, he has already lodged an FIR, so
what has happened to the case?
it's pending, my lord.
My lords,
When
humble
that is
submission.
pending.
Yes. My lords, it's a case of 304 part 1, not 304 part A. 304 A commands a punishment of only 2 years, whereas 304 part 1 mandates a punishment up to life, my lords. And this is a heinous crime which involves moral turpitude. And my lords, as per the judgment, Honorable Apex Court judgment in Amarnath Chaube, fair investigation is a right under Article 14 and 21 as well, my lords. And my humble submission is, my lords, in this honorable court, in the writ petition 5950, the counsels for the respondents, private respondents, have misrepresented and they have filed fake documents and false affidavits. And they have misled this honorable court.
No,
my
no,
lords.
that's before saying all these words of praise for others, you should come to prayer at page 13 in your petition.
All right.
What you are arguing. No, you have read it, right?
Yes, my lords.
There is the prayer in the petition.
Prayer is to suspend the private respondents, my lords.
Then it is not whether it's a 302 or 304A what you are arguing.
Because it's
Prayer is
a moral turpitude,
not,
my lords.
Mr.
Sorry.
If anybody has committed an offense, you can file a complaint against him. The police authority, if the complaint discloses commission of a cognizable offense under IPC, police authority has to register that offense. And if it is not registered, then you can come before us.
No,
This is not a case of registration.
Already registered.
It is not a case of registration of FIR. So don't say that this is not 304A, this is 302.
Yes. My lords, my humble submission, my lords. Like I have written a complaint to the state as well as the center's NMC, my lords. NMC has clearly given in the
Yes, please.
my lords in the
Yes, please go
my
ahead.
lords in the ethics and medical regulations are there, my lord, formed by the NMC Act 2019, my lord. In that 8.2, it says any complaint with regard to professional misconduct can be brought before the appropriate medical counsel for disciplinary action. Upon receipt of any complaint of professional misconduct, the appropriate medical counsel would hold an inquiry and give an opportunity to the medical practitioners to be heard in person or by pleader. If the medical practitioner is found to be guilty committing professional misconduct, the appropriate medical counsel may award such punishment as deemed necessary or may direct the removal altogether or for specified period from the register of the name of the delinquent registered practitioners, my lord. I want to draw my lordship's kind attention to this word of delinquent, and they have been involved in multiple crimes, my lord. And
I will argue, Mr.
my lord,
Listening to you argue.
so kind of, my lords.
Multitaskers, we are
My lord, my
multitaskers.
humble submission is, my lord, like these private respondents, they were supposed to get an opportunity with the government respondents, the state medical council. The state medical council, in collusion, cross collusion, I would say, have rejected my letter straight away, within a fortnight, my lords. And thereafter, I have shot a letter to the National Medical Commission, and the National Medical Commission has replied and also directed the state medical council to take action. And the
What
state,
did Telangana Medical Council do?
they won't come, my lords, even in
So where is what did they do despite this?
they haven't done anything in the single judge writ also. They haven't represented. They haven't filed any counter as well, my lords.
We should have challenged that often. It has been rejected by the Telangana.
Yes, my lord.
Medical Council. Where is which page?
Yes, my lords.
Page 33, my lords.
And interestingly, my lords, on page 37, this rule has been mentioned
Incorrect.
by the NMC, my lords.
approach Telangana Medical Council.
Madam, this thing, Telangana State Medical Council. No, no, you appear, don't appear. Madam, for this thing instance, we want to know, come to page 33,
Yes, ma'am.
right? How it is law and order problem.
Yes, ma'am.
Doctor, doctors sitting in their hospitals by administering the medicine to their patients cause law and order problem.
Well, it's Telangana
This-
State Medical Council may have.
So prima facie, you correct, you can appreciate, right?
Very well, my lords. If they,
Party in person, grievance of the party in person is that, just a minute. We are issuing notice. You want to say, you are appearing for state.
No, that was point, but only one aspect in IA, they are mirrored in the IA prayer. The action, initiate action against the council also, that is only mirrored.
No, no.
Right to.
My lords, I will
You
control
withdraw this.
Ah.
Then
My
don't
lords, like I have,
if you want to pursue your cause, then if you want to take action against council, the High Court is not the forum, some other body, right?
there are 4 Supreme Court, Honorable Supreme Court judgments, my lord, Mandekar brothers.
454
MC Mehta.
judgments.
Yes, yes. For committing.
You are,
contempt on
you are
procedure,
an,
honorable
no,
court,
no,
lords.
we are, you are an advocate,
No, no.
aspiring an advocate.
Yes.
So practicing.
No, not
Like
I'm
this
just
is a
point
this
willing
thing,
to
like
fight,
what
lords.
they call it, what session? Before the,
Yes,
this
yes.
thing, you are practicing by filing a petition that how I will argue, when I am enrolled as an apprenticeship. Don't tell us, Mr. 454 and this thing. For misconduct committed by any this thing, the remedy first is, we are not saying. Remedy is a state bar council. The council is sitting here for state bar council. Go to him. And then,
Not to
if-
make the bar council.
Huh?
I am just the council for the bar
And
council.
that's why we remembered that you are waiting. So you have to go to him like state bar council. And then if does not take an action, no IA, you withdraw this IA. Party in persons, which IA, Mr. Praveen Kumar?
IA number.
Party in person seeks leave of this court to withdraw IA number.
Maybe 3 or 4.
Seeks leave of this court to, with what permission petition? You are not a party to the petition.
Yes, my lord.
Huh? Who has filed the petition? Madam, you should have told, right? He is not a party to the writ petition. Sridhar Dayal, what's your name?
M. Sridhar Dayal.
Then what permission you have filed?
There are 2-3 permission petitions which are filed.
What permission? To
Ah,
appear
yes.
as party in person.
Yes, yes. Yes, my lord.
So that doesn't come before us. That is dealt with party in person. Since the permission has been granted to party in person to appear in person before us, IA 1 of 23 is disposed of. Which IA, Mr. Praveen Kumar?
My lord.
IA, learned party in person seeks leave of this court to withdraw IA number 2 of 2023. The same is permitted as withdrawn. Heard on the question of admission, this intra-court appeal has been filed against an order dated 7 June 2023 passed by the learned single judge by which writ petition preferred by the petitioner has been dismissed. Learned counsel for the petitioners, not delete, party in person submitted that the party in person submitted that the party in person had that pursuant to his complaint made against respondent number 5 and 6, 5 and 6 with regard to alleged medical negligence in treating the aunt of the petitioner. Your aunt,
Father of petition.
father?
Yes, my lord. Deceased is my father.
Maternal aunt, you said
Maternal aunt, and now your father
said.
He is the petitioner.
Treatment, my lords.
No, you mentioned 3 people, maternal aunt, father.
Yes,
and-
yes, true, my lords. Yes, my lords. Yes, my lords.
Then,
Maternal aunt,
you are
maternal
saying
aunt,
father.
father.
Now you are saying father.
Yes, my lords, all 3 people.
Yes, madam.
Well-
What? Who has died?
My lords, as per his FIR, which is at page 30,
What FIR petition, madam? Never meant. You are here, Mr. Praveen Kumar,
My lord.
who has died? He has described in the petition, I think we, if our memory serves correctly, maternal aunt, now he's saying father.
My lord, para 6 of the writ petition, he has stated that
Huh.
his maternal aunt,
Everybody,
there are a couple of people. my lord.
guilty of medical negligence in administrating give the names. Whosoever accepts, then madam say remaining unserved respondents. Yes, next. Password. Password, Mr. Password. We'll try to take up this bunch and medical admission bunch at the end of motion hearing, right? First medical admission, thereafter 1 crore per day loss which you are suffering. Right?
Very well.
We'll take it up. Please wait.
Public.
Yes. Application for, see, this is I told Betty that you are filling up my things on this paper repeatedly. After 2 weeks, if there's no date, please list it.
Unless until this is complete, it should not. We have not filed incomplete. We have directed to file incomplete.
We are trying to get the merit, use data.
Managed counsel for the petitioner praise warrant is granted 4 weeks. Further time.
Unfortunately, one letter should have been written to the registry saying we are taking steps. So matter would not have been listed. That would have.
This is all
some
waste of folks' time and their human effort. They write, we have to sign. And you are just like casual, happy, enjoying weekend. Learned counsel for petitioner praise warrant is granted 4 weeks time to enable him to file an application seeking improvement of the.
Format.
You get per appearance, madam.
I did appearance for, I did 22. I put the rest.
She didn't get it.
Whereas G should get to.
Yes, next.
May I please, my
Let's write, madam. When you stand up, it's their duty to write. We have not said his name also.
May I please, my lords?
Yes.
My lords, item number 126 and see.
What? This is
No, my
24.
lords, that is also connected to this particular writ petition, my lords, challenging the same rules.
What?
Rule 10A for the regularization of the
126,
and 129, my lords.
This is GO challenge to GO 38.
Yes, my lords.
120.
126 is serial number and 129, my lords. In 126,
Yes.
we have petitioners.
126, write her name, heard on IA number. In this petition, the petitioner has assailed the validity of rule
38,
GOMS
Arrange to regularization.
38, my lords.
38 and GOMS number 60.
by which the services of the person sought to be implemented in this petition have been regularized in violation of
Yes,
law.
we have,
According
challenged
to
for
the,
this.
just a minute, according to the petitioner,
16.
the aforesaid action is in violation of law laid down by Honorable Supreme Court in Uma Devi, State of 2006, Volume 4, SCC, page 1. In view of aforesaid submission, issue 30 or quarter to 1, we will start.
Excluding 20.
Excluding 20.
29 deals with cap quota.
Cap quota is different. We will deal with her case also.
Yes.
She did not tell us that her case is different. Yes. Madam, you did not tell us yesterday that your case is different, right? Your case is cap quota. Nothing to do with this thing, local candidate. You didn't say. Fine. Thank you. Sit down. Yes. You are all dependent on the courts, right? Court should read, court should make out a point, grant relief to you. You will just stand up. Wish this service was there with when we were practicing, we would have never crossed over. Unfortunate. Thank you. Yes. 50. 50, madam. This is password. Up to 49. No, not, yes.
NCC is also.
NCC is different.
Within the medical only, NCC horizontal.
Acha, then 44 probably, up to 43 is this thing.
25 to 28.
No, I have written that, but this up to 43 probably.
43 to 37. 33 to 37.
My lord, what they've done is the entire medical batch at 2 years. Up to which number?
Two only ballots, but
Up to
my lord, 33, 34, 35 and 37 are NCC matters.
42.
Yes, up to 42 is.
Hey, we know it, mister. We
Yes.
have read it.
Yes, sir.
We are not dependent on you. Because nobody told you. Yes. We will take it up at the immediately before lunch. I mean, not immediately, whenever it time. We are trying to finish other things fast. You be available if you want to argue your case.
43.
43.
My lordship,
43. Nothing with 43. You are appealing? 43. Madam. Yes.
We are for the petitioners, my lords.
Ah.
We have received the
Counter.
counter only today, my lords.
Learned counsel correspondence, learned counsel for the petitioner submits that she has filed a counter. She has
Received the counter
received the
today.
copy of the counter today. She prays for adjournment to enable her to go through the same and to file. And to file a reply to the same. Let this be done within 4 weeks. You say petition is in the beginning, madam, for admitted for hearing. Yes.
Obliged.
44
Lord, if I may.
notification, Mr.
Yeah, may I please your lordship. I am appearing for petitioner, my lordship.
Lord, if I may intervene, my lord, item 24 is not the batch, my lord, it's a
It will be called. We know, madam. You are not seeking admission to MBBS course.
No, this is.
That is different.
is different, right?
That is environment.
24. SEZ causing.
Item 24 different.
24.
SEZ causing pollution.
24 is a pollution matter.
Pollution matter.
Regarding this matter,
24 what?
I'm saying the 1 week
Who
time,
appear?
by 1 week time by filing the report.
24 matter.
It's only for status report by TSHC.
Lordships, I have instructions to appear for
Sorry.
12.
Sorry, we missed this.
Let me make one.
No, madam. This is no. This you are giving 29. We are saying 24.
May Lordships find leave, my lord, and
1 minute. We are not running away, mister.
my lordship,
Nobody told that we are running away. So you are saying you are behaving as if the court is about to rise.
At 26, I am only trying to, that counsel on record suddenly fell sick. Milord, he requested 10 days time. Milord, K. Bhima Rao. I only wanted.
26.
Yes.
1 minute. We will call it. It is an admission to medical cases,
Yes,
right?
MBB.
Then when it is called, you make a prayer.
I'm ready.
Supposing if Mr. Rao says that I don't want interim order to continue, there is an interim order in your favor. Out of turn, make a mention and run away.
No. Since
No interim order.
there is no order, I am. Milord,
No, these are.
he only requested me over telephone.
No, it will be.
Yes. Milord, I'll make a request when it is called.
Thank you for this thing. Mr. Compliance report.
item 24, my lord, in one week time of filing report, my lord, in this petitioner, my lord, he filed an
No,
opposition.
Mr. We will impose costs on you.
Yeah.
For you, because your inaction. No. Your inaction, people trouble us, and you here also you seek time 7/8/2023, time was granted, again seeking time.
Yes, my lord, morning the instructor, my lord, the petitioner, same petitioner, filing the OA, my lord. OA before the green tribunal that is pending, the same relief, same petitioner. OA 24 of 2023.
Be ready to pay costs if it is so.
Okay. I deny, my lord, that's not the same relief.
24. 24, write her name, and Council for Pollution Control Board again prays for adjournment to enable him to file status report, compliance report.
Lordship,
Late after 4 weeks.
Lords will file a counter, my lord, for Act 12.
Notices are not yet served to the other respondents.
No, we said after his report, we will decide whether notice to be issued or
He's appearing for one of the private.
not now.
I'm sorry.
First, let the pollution.
May I please your lordship? May I please your lordship? My lord, item number 23 is not pertaining to medical admission. The counter not yet filed. We are for the petitioner.
No, order has been passed, madam. You woke up late. Good morning to you.
We are aware that it relates to regularization of services.
Yes, madam.
That we have said.
Good morning to you. You woke up late. Yes, it's all over. Don't behave like this thing.
Rajeshri was there, we have. Yes.
Yes. 44. 44, what happened? Mr. Council.
Sorry, I am
No,
presenting.
no notification has come.
No, I filed report.
No, Mr. Last date of hearing.
About 800 pages are there, Lord, and 6 part.
All right. So you are not reporting compliance of directions. Who will appear? HMDA, who appears?
I am appearing for the HMD, I have submitted report, giving the details of the.
So, Mr. We are asking you whether notification you have produced. You should say yes. You are saying that report, not.
Not 800 pages are there. We are making it not within 2 days, we will be filing it.
52 days. No, within 2 days.
My lordship, may I please your lordship?
No, we will call him your officer.
When it's, I filed a report.
No, Mr.
Within 2 days.
No.
Yes.
You don't know the order passed in your presence on 11/8/23.
I was directed to.
What?
Notification.
Learned Council for Respondent number 8 submits that there are 3532 water bodies situated in limits of HDMA. Out of aforesaid 3532, HDMA has issued notification in respect of 2497 bodies. However, aforesaid notification has not been placed on record. By way of indulgence, hearing is deferred to 19/8/23. Don't write, madam. He has not read it, so we have to tell him, right? Don't write. We have to tell him. We have to read out, see our plight. We have to read the council the order, then only he will smile. So he is no duty. He is dependent on us, our case. So I am this thing. By way of indulgence, hearing is deferred to 19/8 to enable Learned Council for R8 to file compliance, report compliance of directions contained, failing which appropriate order shall be passed. So there is no compliance report. No. May I submit is no answer. The first answer is either yes or no.
Compliant, some more others are compliant, some more required notification, which were. May I please your lordship? Wrong facts are being said. I will assist the court.
Obviously, he is submitting wrong facts.
Compliance report is filed or not is the question, my lord says.
Not fine.
So it is true that the lakes have been finally notified and even 2000 odd lakes have been preliminary notification.
Have they filed the compliance report?
Lordship, that's the identity.
Have they filed it?
No, my lordship.
No, fine.
So mentioning.
Learned Council for the petition. All right. Learned Council for Respondent number 8 once again prays for adjournment to enable him. No, nothing. The order dated 27/7/2023 has not been complied with, correct? You are seeking time. We will direct the commissioner to appear.
Cannot say lot. 230 lakes have been finally notification. Request plot page number 6 may kindly be seen. 230 lakes of final notification has been issued. And regard to the 2000 not Wilbur notification has been issued in respect of 58 page number 58. And I submitted.
He only made statement. Policy, they don't know.
Page number 58, 2058, Cleveland notification has been issued. And remain, lakes are required a lot. I asked the file.
No,
Mr. Third time we are asking report, have you filed? You are not saying, making submission.
Submitted, like.
Well, say so, first sentence. That I filed the report. That third time we are asking you,
Report has been submitted.
why is it so difficult to say that report has been filed?
Sorry.
When it has been filed?
It was filed on 88.
You couldn't have said this, that 18/8/23 has been filed, I have filed.
Date.
My lord,
Go
this
through
is
the
not a
report.
compliance report.
Go through the report and give your objections to this.
Yes, my lordship, this is not a compliance report. What they have done is they.
He will take him to, he can't disappear, right? Huh? He can't disappear. He is not at flight risk. Commissioner, who is Hyderabad commissioner, who is not at flight risk. Shall we say that he will not leave country without our permission?
case was only with regard to one lake, which we have.
My lordship, they are actually.
Mr. Counsel, you should understand one thing. Your complaint was with regard to Ramamar Lake.
I am coming to that.
No.
Hey, coming to you, go there somewhere.
We have enlarged the scope to see that all other lakes are also, so he has filed some report. We do not have the benefit of the report and we are running against the time.
And you
I would
should,
like to
no,
assist my lordship.
no, you should think that always this thing, don't fight like a neat aspirant for admission like senior counsel who's sitting here.
My lordship.
You are here to assist us.
Absolutely.
Repeatedly, we have been telling these people are waiting for us.
Much of it.
Huh?
My apologies, my lordship. I would like to assist the, because I have some very relevant information on this.
Fine, it is not before us.
Much of it.
He is not even telling us. Only when we threatened that commissioner will appear, then he said that I filed the report. This is the level. What can be done?
Fine.
In compliance of the order dated 27/7/2023 as every time
My
standing
lordship,
apart.
there is a second direction also, my lordship, in this, which
Consider.
is undertaking by commissioner has to be given by GHMC with regard to Ramamma Kunta Lake.
List
They have
after
not
1
done
week.
that.
We have said, no, you have disputed that not a compliance report.
This is
He-
for a, this is
No.
for notification of lakes. I am talking
Do you-
about Ramamma Kunta Lake.
Whatever lake, do you want to say that the authority shall leave after selling all the properties and would be available after 1
No,
week?
no, my lordship, this is another IA, this is an order in the IA, second direction, which was said that an undertaking will be given by the commissioner.
I understood, but we are not deciding anything on today. Are we saying that it has been complied with? So you are arguing that that is not complied. You are, as it is, you have said that there is no compliance.
This is for notification of lakes, my lordship.
It is not that difficult, Mr. You are not asking us to review Keshwanand Bharti, right?
No, my lordship.
We have understood. But what we are trying to tell you is that we are not adjudicating anything. All issues, including another lake, is also open to be agitated.
Much of it.
On the next date of year, this lake also.
Construction
Everything.
affidavit.
We have said that whether it's a compliance report will be decided on the next date of hearing.
Much of it.
It's not being done.
Much.
My lords may make one submission, my
With
lords.
your effort, Bob. Very difficult. We should take no date after 1 week. Yes. Not impleted. This repeatedly coming up.
No, this 5 day
IA. Issue notice of the IA 1 of 23 to proposed respond.
Personal notice, say.
Personal notice, proof of service. That's a standard, right? Yes. Today, commercial appeals, we can't hear. These people are appearing in commercial appeals. We can't hear. Registered suo motu. Yes, so.
Last occasion, the third respond was directed to file a status report.
So if the matter is pending with you, what have you done?
Status report.
Not status report.
It is not come. It is up.
Respondent number
Director
6 has,
Department of Heritage.
respondent number 6 counter in this. Counter by respond number 6.
Report was
Give-
come from Director
No, this
Department
what
of
they've said, no. 3, that's what, there. Yes. It's there, madam, the flag put all, I have read it yesterday. Yes. The respondent number 3 has filed an affidavit, an affidavit in which it is stated that memorandum of
When I'm representing Vivek Jain, without counsel for respondent, that's why I come to 2 days without,
correct. Why?
because for 2 days, without, Vivek Jain's, family member, one of the family member is ill health.
Mr. So and so respondent praise for adjournment on the ground that the arguing counsel, Mr. Vivek Jain, is not available on account of personal difficulty. List.
2 days time may be granted. Malad, any condition.
List after week.
Next week.
After week. Oh, yes.
Publish.
40. Yes.
May I please?
This item 48 and 49 go together.
Yes.
I'm appealing for the respondent petitions for.
That's on 7th March 2018 appeal got admitted.
Ah.
And on 7th March 2018
Yes.
appeal was admitted
Ah.
and interim order was made absolute.
Yes.
But it has to be heard finally. ma'am.
Yes. The appeal, mark the presence, the appeal has already been admitted on
7th March 2018.
7th March 2018 and interim order has been made absolute on
Same day, minutes on 7th.
Not absolute, it was
And
granted.
extended until further orders. It says.
and has been, there is an order, right? Has been extended and yes, correct. By an interim order dated 7/3/2018, the appeals have been admitted and the interim order granted earlier is extended until further orders. Full stop.
We filed vacates petitions is 22, Madam.
48, 49. Full stop. Therefore, yes. 48 you have filed vacate petition.
Filed vacates petition is 22.
So after a period of 5 years, they have filed 2017.
We will hear it and
What's the
Any day, my lord.
candidate for hearing?
instead of passing any orders on IA 1 of 2022, which is pending consideration, we deem it appropriate to appeal to hear the appeal itself finally. Fifty to 52.
52, all the three minutes.
I see time from.
So 7, 8 also you had short time, right?
Yes.
By an order dated 19/1/2023, the appeal was directed to be listed in usual course. Let the same be listed in usual course. 52, then 53, madam. So this all admitted and stays operating.
Yes.
Mark the presence, the appeals have already been admitted for hearing on 13/7/2022. Just a minute.
Right.
Everybody's presence.
In fact, when this vacates petitions have come up for hearing before the Honorable Court on 27th of April 2023, there was an order passed by the Honorable Court saying that no order is called for. Post them for final hearing in the usual court.
Yes. If you, we were about to, we have noted it down.
Correct.
Mark the presence.
Yes.
The appeals have been admitted for hearing on 13/7/2022 and orders imputed. Today is a day meant for students who are waiting to get into MBBS.
true, but any other date.
2022 appeal cannot be heard like this. What is the sin? Please tell us, senior counsel. We have appeals pending since 2005 intra-court appeal. Last week only we delivered a judgment in 42 cases. Absolutely no justification. Please file an application, we will consider. Prepare a synopsis. We can't grant you 1.5 hour each for whole day for 22 appeal.
File applications what we consider.
And this thing along with synopsis to cut short. This is dispute must be dispute pertaining to properties running into crores. That's why all senior counsels appearing, nothing except value of property. And the principle of law, I can tell you with my experience, we can tell most elementary, like 2 + 2 is 4. Correct?
Both of us are there at the beginning.
That's simple form.
That's it.
Administrative law point of the property to be presented.
Yes. Sure, it would be our pleasure to hear you on some time. Yes. Yes.
Obliged, my lord.
Yes. Stay one post office. None. Yes. An interim order has been granted on 14/11/2019. However, none has appeared to argue IA 2 of 23. The interim order shall continue until further orders. List after 4 weeks. Yes. Counter. This, let's file a counter. Learned counsel, let counter if any on behalf of respondents be filed within a period of 4 weeks. 66, madam. 66.
Also counter such a file, my lord.
66.
Section 150.
66.
Counter such a file, my lord.
Who has to file?
But all the respondents, my lord, none of the file. And notice
None for the petitioner record perused. A petition is admitted for hearing. R7 served, madam.
R7 notice has to go.
Issued whether served or not. Let proof of service for respondent number 7 be filed within 3 weeks. In the meanwhile, it will be open for respondents 1 to 6 to file counter if so advised. Admitted for hearing, no matter. Yes. Then Shrikant Suri. What? The pollution control board, nobody appears. Petitioner shall apprise with none for the parties. Petitioner shall apprise this court with regard to the steps taken for service of notice on respondent number 3 and to proof of service filed, madam. Office report indicates delete. None for parties. Office report indicates that notice issued to respondent number 3 has been received back unserved. Received back with an endorsement. The respondent number 3 has not been served. Let steps be taken for service of notice on respondent number 3 within 3 weeks. The council shall file that whatever personal notice, proof, mode, whatever proof of service. Yes. Next. Narayan Sen.
And I'm appearing for the petition.
Yes. Counter.
Grant some time, Lord, filing counter. Rules are done challenge.
Admitted for hearing, let counter if any on behalf of respondents be filed within 4 weeks. 69, madam.
Because this matter levels we have filed simply counter as well as we have filed our defense. This matter will become take of your.
Pleadings are complete. Pleadings in this writ petition are complete. The same is admitted for hearing. Yes. 70. 70, madam. Say.
This matter also. Both the different matters. This matter we have yet see the counter.
Not received. Let counter if any on behalf of respondents be filed within 4 weeks. Next.
Your last occasion, my lordship directed me to give the cutoff marks of each candidate.
What is it?
I prepared about 10 districts, remaining district also I'm furnishing.
No, but this thing, how many petitioners then are above cutoff?
About 10 or 15 people, my lord, in respect of certain cases. In respect of Hindi Pandits, my lord, we are still calculating. But school assistant and language SGTs are, my lord, only few people have been qualified.
So you give the details who have qualified.
My lord, I'm giving the particular numbers also, my lord. Your lordship, I'll furnish, my lord, lordship, kindly pass.
They may also furnish to us so that we will also know.
Will kindly pass for, my lord, I'll furnish.
No, not in compliance, but names of the petitioners.
Yes, hot ticket numbers, names and their cutoff marks, their community wise also I'm giving.
So give
Where they
petitioners.
stands.
So like WP number so and so petitioner number 1 supposing this.
Yes, please.
In compliance of the order dated 1/8/2023.
Exactly.
Learned counsel for the Standing Counsel for Telangana State Public Service Commission submits that he has filed the chart, filed the statement indicating minimum cutoff marks in each of the category and whether any full stop. He, however, prays for how much time?
Pass over only I'm asking, I'm getting. Not today itself I'll furnish.
Today is the day for MBBS thing, right?
Very well.
We have been repeatedly telling.
Lordship, taken up next week, I'll furnish.
When that tell us?
Next Monday.
For short adjournment to enable him to file a statement. Into containing the names of the petitioners in this batch of writ petitions who have secured more than minimum cutoff marks. Needless to state that such statement shall be shared with learned counsel for the petitioners on or before next date of hearing.
1 week.
Tuesday.
Yes.
Tuesday. Next Tuesday. What day? 29/8/23. So 71 to 111. Yes, now. Mr. Senior Counsel, you give a synopsis also.
Yes, Lord, I'll furnish.
We'll see. Give a synopsis so that if possible we can hear it. Yes. There is counter. And then it yes. None for the petitioner. Petition is admitted for hearing. Let counter, if any, on behalf of respondents be filed within 4 weeks. 113.
But in this matter, I have filed on counter of it 1 and 3. 1, 2, 3.
Learned counsel for Mr. Praveen Kumar, learned counsel for respondents number 1 and 3.
This petition has been dismissed without due respect because the complaint registered. Judicial number the cat.
Just 1 minute. Learned counsel for respondents number 1 and 3. Learned Mr. Praveen Kumar.
1, 2, 3.
DSCI. For respondents 1 to 3 submit that he has filed counter on behalf of aforesaid respondents. It is further submitted that this has challenged virus of a provision.
Virus will not the subclass 3 of section 2 of the administrative tribunal in the case of personal judges. We are made complaints. During the course of discharge me duties for judicial functions. Certain comments have been made, all those will not made in the complaint. Kindly see.
So Mr. You represent 4 also.
No. I don't represent because we not wanted to maintain the judicial equilibrium.
So nobody is present today. We will record your submission. Learned Deputy SGI submits that writ petition
itself is not maintainable. That
the writ petition should be dismissed as dismissed qua respondent number 4.
Yes, sir.
Should be dismissed qua respondent number 4 as his action on the
judicial function
on judicial side as That she is not saying.
We'll go back to medical admission.
No, she was saying 129. Shall we call it? Let's see. 1 minute, 5 minutes. A call 114 to 121. So if we have to understand. 114 to 117.
Please, these are
Yes.
matters remanded by your lordship. I recall that people were displaced of their properties. At the time of displacement, they gave the checks to some of the petitioners and they bounced.
Also, yes, checks have been handed over.
Only to 9 people has been handed over.
He only smiles and doesn't say anything. He says civil suit.
Special GP Sanjay Kumar is appearing in this
CS
matter.
14 of 2015.
Special GP Sanjay Kumar.
1958.
In this matter, Special GP Sanjay Kumar is appearing. I request you
No.
kindly start transfer matters.
Arey, Mr. You are Mr. Rao, right?
Myself, Santosh Kumar matters.
Pars Anant Nageshwar Rao. He is not there. So shall we pass it over? We will hear the medical people, candidates seeking admission. Pass over there. All right.
Much up.
So then go back to now.
Wait, please, Your Honor.
1 minute.
Item number 63, Lordship.
1 minute.
Was not taken the matter.
Order has been passed.
Already, Milad, subsequent notification released, Milad.
You want to withdraw?
No, Milad.
Then?
Milad, likewise, Milad, implemented the
No,
act, reservation for
we
the
have-
60 people as per.
We have given time. Mister, it's not that when the case is called, you won't appear and then interrupt the court and ask what order has been passed.
No.
Find out from him.
No, Milad. I am
No,
here, Milad.
we have passed an order. Yes, next.
Milad, already, Milad, the government has decided reservation, Milad, 15% by public health, kindly see, Milad. And notification only 10% is declared.
Which is the matter, when the matter is called, there is no representation. Whenever you feel like you come and interrupt the court proceeding. What is this happening? Is it the first?
No, Milad, I am Milad, but not, matter is not taken.
Sorry, you are not heard us. We have heard all the matters. Which is the matter?
So, it is taken, Milad.
I will tell you which is the matter we have heard, what orders also we have passed, we will tell you.
That's what he want to know.
Sorry, date is given. Yes.
One by one, madam. It can't be a bunch. When it comes to granting interim relief, everybody is one. When it comes to arguing, every case is different. That's why so many senior counsels now we can see. And Mr. Prabhakar Rao alone is facing all of them. Yesterday's Mr. Rao, you have the copy of the order which we passed in detail. Some lady consul had argued. Your item is 25, madam. Sit down. 25 has been called. You told us no, one by one. We are taking one by one. But and these are all different matters, right?
We can group them into three. But in my case. No, 1 second, 1 second. We can group them into three groups. One is challenge to rule 3(3)(c)(2).
His petition is 25 is challenge.
25 is 3(3)(c)(2).
Rule
3 within bracket Roman
C2.
within bracket C
I've
within bracket
got
2
that.
of Telangana Medical and Dental College admission rule.
Yesterday we signed, madam, 5 o'clock we signed an order. Mr. Prabhakar Rao had argued and Advocate General. Get that copy of that order. So this is the rule challenge validity of to rule 3 is which case 25?
25, 26, 27, 28, 30, 31, 39,
31, 39.
40, 41, 42.
So we will take these matters first.
Madam.
So Mr. Senior Counsel, you have challenged the validity of rule 3(3). Just a minute. You speak then. Please.
Alternative submission in the event where if my contention is accepted, I will throw it for a moment. I am arguing with some other. But
Mike, Mr.
Matter relating to, but the mic in mic.
No. Now will you listen to us?
Yes, definitely, madam.
So we were only asking the question whether you have challenged the validity of Rule 3C2 of the rules.
Madam, I am challenging the rule.
1 minute. We are not asking about alternative relief.
Yes.
We have to pass orders also. That you don't do. Other council doesn't do. We have to. Brother is telling me we have to. You just argue your case and go away, have lunch. That's not done, right? You have here to assist the court. We are asking you. You are challenging the validity of Rule 3C2, correct?
Yes.
And along with you, Mr. Now we are telling everyone whose number is called, he should stand up. That in item number 26, 27, 28, 30, 31, 39, 40 and 41 and 42. Mr. Rao, correct? Validity of Rule 3C2 has been challenged. So therefore, after senior counsel argues, whosoever wants to argue, these cases will be decided by a common order. Whatever we have said. Note down, madam. They will not note down. We have to pass a judgment. They are not concerned with anything. Yes. What is the challenge to the rule?
The rule, but the validity of rule, but alternative submission. But first I will deal with the facts of the case. But if your lordship not considered that, but then I will go to the rule. But for a moment I am saying it's an alternative prayer. But I made a short synopsis.
No, everybody else is, Mr. Senior Counsel is banking upon you. All these young people, how can you abandon them by saying that I will not argue the challenge to the validity of rule? It's we understand you are more anxious in alternative relief, more anxious, but you owe a duty to your colleagues. You are a senior advocate leading all of them in this batch. So you owe a duty to them to argue the validity of Rule 3C2.
I will come later. Now,
all right. If you don't want to argue, then we will hear somebody else who argues.
I will argue.
Then please sit down. But we shall we record you are giving up challenge to Rule 25?
But alternative prayer. Alternative, I say that, but may not situation may not arise. Once your lordship agrees,
then we will hear you later. Then sit down. Sit down then. Please sit down. We thought that you are a senior counsel, so you have a right of audience. You are giving up your right by saying that I will sail by the wind. I will sail by the wind. If I see that Rule 3C2 is succeeding, then I join. Otherwise, so don't bank upon him, mister. He is a fence sitter, seeing that if the challenge to rule succeeds, he will join you. Otherwise, at the earliest possible opportunity, he will abandon.
The contention is the challenge to that.
Fine.
That's all. Well, in fact, that's all my.
Which case, madam, Mr. You?
Next, after him,
26.
We are 27.
27. No, there is one case in between you, senior counsel, and you. And which other case?
The lady who argued the other day.
She is not here, lady.
Mine is 30 lordships.
30?
Yes.
And then, where are?
26.
26. 26. No, you are challenging the validity of Rule 3C2. Correct. No. This rule is different for everybody. This rule is different for every petitioner or same? Mr. According to us, there can be like three grounds of challenging the validity of rule. That the rule making authority has no power to do so. Secondly, it is in violation of fundamental rights, Article 14, etc. Third is, in case of a delegated legislation, the rule making authority has traveled beyond the scope of delegation and has framed rules in respect of a subject matter which were never delegated to it. So we don't know what overseas student or Indian student. You have not challenged the rule.
We need to challenge it.
Then argue on validity. We will decide it.
challenge, so we want.
Not challenge.
He has not challenged, he wants time to, time 26, he wants time to.
Amend the prayer.
So you want an amendment, adjournment. No, but these cases are being decided. Your case will follow whatever. Mr. Rao, correct? He is seeking an adjournment. You want to oppose the prayer.
Because whatever orders passed to it, it will approve to pretty much.
His case also, he is giving an by seeking adjournment. No difficulty.
Party fell sick, I do not open the affidavit because I need to amend the prayer. When the council
I think if the matter is dismissed.
but next week.
No, supposing if the challenge is repelled, your case is a foregone conclusion. Then we will ask you, why should we not follow our decision, right?
Start prayer under.
We don't know. No, we don't know who is doing what. Don't waste time. You want adjournment in which case?
Next week, any day.
Which item?
26.
26. Learned counsel for the petitioner. Huh?
On the next slide, after your lordship.
No, 26 he is seeking adjournment. We thought that you are opposing his prayer. So you immediately stood up. No.
Let's go to the next one.
No, in that case, who is senior between you and him?
I'm not appearing in this matter. I'm not appearing in this matter.
No, the other one senior. Who is senior between Mayur and same? Both are same age. And candidating and say alternatively serve with this in case. He's running away. Item number 26, learned counsel for the petitioner. Praise for adjournment. Arey, Mister, why you are seeking adjournment is because there is an interim order. Sorry. Your case. No, 1 minute. Item which case? 26. Oh, sorry. We were looking at 25. No interim order. Mr. K. Bhima Rao. Learned. Mr. 10-8 also you were granted 10 days time. Mr. K. Bhima Rao, learned counsel for the petitioner, on 10/8/2023, learned counsel for the petitioner had sought 10 days time to enable him to amend the prayer clause in the writ petition. However, when the matter is listed today, again he prays for adjournment, list after a further period of 10 days. 2 equal installments, 10 days each. So first 10 days, fine. We are not concerned. We are thinking about ourselves that since it should not be less than 10 days. Yes. So which case, who argues, Mr. Don't wait for us.
Is arbitrary, unreasonable.
But then,
but it has to be read up. But in view of the Supreme Court,
which case? 25. 2-1-2-6. At least he has to give fair facts. So it's like tell him. We are hearing you fine. Mr. Rao, you are ready, no? This is to be heard finally. Challenge to the validity of rule, counter, etc. has been filed.
Yes.
Senior, just give us the small brief of the facts And that's why the challenge, because it's a 2017 GO.
Yes, sir.
Which is being challenged in 2023.
Yes, sir.
So what made you to challenge it now when it is in existence from?
Yes, sir, then I will deal with that. I will deal with the matter. But I am prepared, not to. But you suffer in my case is concerned.
So at least, Mr. Rao, please give us a date of this thing. Date of NET examination. Nobody tells 23. We like to be specific. Please give us a date. Ask authorities if you don't have the date. They say 23 NET examination appeared. They don't give what date examination was. For sake of completeness, we want to say.
But the NEET result is declared, correct?
No, when was the exam held?
13/6/2023.
That is the result declared. That we have seen.
13/6.
Examination, you have said just about 23 it was held. Any of the councils, nobody knows when it was held. Mr. Mr. Vivek Reddy, you also don't know.
My code is very noted,
No, we are asking the date of NEET examination, not asking you to argue the matter. Senior counsel is standing, since he is not telling us the facts, we are reading from his file and gathering the facts. He has straightway come to submission. 7th May
23.
appears to be not sure, madam.
Check the NMC website, Manoj.
7th May.
7th May is.
All. Thank you. Where is GO in this? Roof sheet. So see me, I see really good page I'm amazed to see. The G starts, no. I want to put GO in this. GO 1-1. But this is also unconstitutional, arbitrary. They should say which particular rule. I think that's the prayer. Ah, yes, senior come. So please come to prayer clause at page 16 first. Prayer.
It displays, the writ of mandamus declaring the GOM is so and so unconstitutional, violation of
So,
Article 14.
and please come to GO at page 18. GO at page 18. Page 18, what you have challenged unconstitutional. It is rules, right? Rules.
Yes, sir.
Entire rules are unconstitutional. Which provision?
But only in respect of the interpretation of the local area.
So what are you challenging? Whole rule? That's why we made you read the prayer clause. Is it whole rule or
But only confined to local area.
which rule?
That the rule, Your Worship,
So we will record that you have clarified today that challenge is confined to which rule?
on page 20, paper book page.
That's why you appreciate we were unable to understand what is challenge.
Yes, but page of the paper book, Your Worship.
20. 20.
Page 20. Be local candidate. Rule 3B. Roman rule 3.
3.
Roman rule 3B.
B. Rule 3B.
Local candidate. Class A and class B. Either.
So which clause you are challenging rule 3B as a whole?
Rule 3B.
As a whole.
But my submission is.
So please read what is 3B.
But 3B, the local candidate, a candidate for admission shall be regarded as a local candidate in relation to the local area. If he has studied in an educational institution in such a local area for a period not less than 4 consecutive academic years, ending with the academic year in which he appeared, or as the case may be, first appeared in the relevant qualifying examination. Or where during the whole or any part of the 4 consecutive academic years, ending with academic year in which he appeared, as the case may be, first appeared for the relevant qualifying examination. He has not studied in any educational institution. If he has resided in that local area for a period not less than 4 years, immediately preceding the date of the commencement of the relevant qualifying examination, which he appeared, or as the case may be, first appeared. But I am challenging this. But a candidate, but I'm reading after P. But only to the extent of this, only I am challenging this rule. In All India services, the students belong to the All India services, parents belongs to All India services as unreasonable. Violate Article 14. Therefore, in view of the law laid down by the Supreme Court, it has to be at least read down. Well, a similar rule was read down by the Supreme Court and Bombay High Court. Though it is unreasonable, but their lordship did not struck down
What's the process?
So what do you, insofar as it pertains to this requirement?
Children of parents belong to all India services. But I'm
Is,
confined
uh,
to
uh, all India services is what arbitrary?
IAS, IPS, IFS,
Huh. All India services
all India service,
is arbitrary.
arbitrary, unreasonable.
Huh.
In view of the law laid down by the Supreme Court, but I am confining my submission,
Which Supreme Court?
but I will read that. In confining my submission, it has to be read down. So what the-
Requirements of the rule have to be read down what so as to not to apply to children.
Children belong to the parents of the all India services.
Rule 3B. Rule 3B. 3B. The rule 3B requires to be read down so as not to include,
Not to applicable, not to insist,
so as to not
to insist,
just a minute, applicable to,
insist.
not to be applicable to children whose
Pertaining to
parents
parents of all
parents
India services.
belong to all India services, right?
But I am reading the, your lordship's a permit, will I am reading for 1989 3 SCC, page 112. But a similar rule was interpreted. But short judgment I will read so that Lordship will appreciate the facts. And I will ask you to. On July 31st, 1987, we allowed the petition directed by the respondent to admit the petitioner. The so-and-so, one of three Delhi Medical College in the first year course prescribed with so-and-so course. We said the reasons would be pronounced later. We proceed to do so now. The petitioner was born in Delhi on so-and-so. Her father is so-and-so was employed in National Council of Education Research and Training. and her mother, the so-and-so was employed in government girls senior secondary school. The so-and-so, the petitioner attended the junior public school in Shakti Nagar up to class 2 and Cambridge so-and-so school in New Delhi up to class 9 to up to January 1982. Petitioner father was placed on a deputation in January 1982 with the government of Nigeria to serve in its Ministry of Education through Ministry of Home Affairs, Department Personal So-and-so. The government of India, the petitioner who was a minor at the time of it, had to accompany her parents along with her minor brother. In Nigeria, the petitioner continued her education as an overseas candidate and appeared for examination conducted by University of London in Kaduna, Nigeria, and she passed a general certificate of education ordinary level, which is recognized by the Central Board of Secondary Education, New Delhi, as equivalent to class 9, class 11 in India. Paragraph 3. On completing the period of his deputation, on April 8, 1984, the petitioner's father returned to India with his family. The petitioner was admitted to class 12 in Delhi Public School, and the Central Board of Secondary Education permitted her admission to that class. The petitioner appeared in All India Senior School Certificate Examination conducted by the Central Board of Secondary Examination, New Delhi.
Now you have supplied this to Mr. Rao, we believe.
Yes. New Delhi in 1985 and passed the examination. The petitioner then sat for entrance examination for admission to one of 3 medical colleges in Delhi, and she obtained 750 marks. The candidates who obtained an equal number of marks or even less were granted admission. The petitioner was denied admission. She fell for consideration in the quota of 70% of seats reserved for candidates who had passed a qualifying examination from University of Delhi, or the Central Board of Secondary Education, or the Council for Indian School Certificate Examination from recognized schools.
Mr. We have read it. This Supreme Court has not declared the provision of particular provision to be ultra vires, right?
Yes.
And has taken a view that denial of admission because her parents or her father was transferred on deputation to Nigeria, and theoretically speaking, petitioner ought to have stayed in a hostel. That is not always possible. So Supreme Court said that it is denial of admission to her in Delhi quota seat merely on the ground that she has not completed the study in 2 years in Delhi is unreasonable and directed admission. But 1 minute.
Yes.
1 minute. Therefore, the thing is that the Supreme Court, the validity of the provision, we don't know whether was under challenge before Supreme Court. But from the order, it is evident that the Supreme Court has not struck down the rule saying that it is arbitrary. So therefore, one of the possible submissions of Mr. Rao can be that this is an order under Article 142 of the Constitution of India, and your lordships do not have power under 142. So this can be. So how do you meet this?
Yes, I will read the only few lines in paragraph 4. Then I will explain.
No. Whether the provision of rule have been struck down?
No.
It has only been held that denial of admission in the facts is unreasonable.
No.
Correct?
But I will go to that paragraph 4. It seems to us qualifying condition that candidate appearing in the entrance examination for admission in medical college, Delhi should have been received last 2 years of education. The Delhi is unreasonable. That is my.
It has been held to be unreasonable.
Yes,
But
therefore, my dear lordship said it has.
fine, fine. All right.
This sir.
So then what else?
But
So this Supreme Court judgment according to you.
just for my satisfaction, your lordship.
Yes, yes.
But after 10 lines.
No, senior counsel, what we always appreciate is, and we are telling it everyone, like if you tell us these are my submissions 1, 2, 3 and elaborate later on, it's very good. So why we are inquisitive is to know what is your next submission, because you only referred to Bombay High Court and now you are reading para 5.
No, I'm saying.
We will read the whole thing, but if you could tell us that my next submission is Bombay High Court, third is like this, fourth is like this, fifth is like this, then you can elaborate.
Yes.
That's better.
My first submission, man. I have already submitted to your
First submission is that the aforesaid requirement in the rules in respect of parents belonging to All India Services is arbitrary and unreasonable. Second submission is such a requirement should not be made applicable to children whose parents are in All India Services.
Yes.
And the rule has to be read down.
Yes.
In support of that, you have read this thing. You are relying on 89.3 to say that denial of admission is unreasonable.
Yes, madam. That is the fact.
And other is Bombay thing, right?
The judgment is not under Article 142.
No, that you can argue, of course. We just told that put you on notice what Mr. Rao can argue.
Maybe, but
but if we wanted your response, you will give. What is the second submission? Please tell us.
My second submission is this rule, present rule, or local area condition cannot be insisted. Cannot be insisted for the children belong to the working in All India Services.
That we have noted down. We just now told second submission.
The second submission is the rules now they are saying the rules they are not the present rule.
No, just tell us, then you elaborate, right? We are not saying that we will not hear. So what is the third submission? You referred to some Bombay judgment. What is the judgment?
I will come to Bombay, but then your worship, the second my submission is the rules are not framed under the presidential order. The rules are pertaining to local area. B and 3B and small b is not framed under Article 1 presidential order. Article 371D.
Presidential order of 1974.
1974.
Yes,
1974.
37-1974. 37-1974.
37-1974. All right. So therefore,
this rules has to be without reference to the presidential order. The rules has to be read down independently.
So therefore, rules have to be read down or struck down.
Rules has not struck down. Rules has to be read down independently without reference to the presidential order.
The rules have to be read
independently.
Correct.
Without reference to the presidential order. But there are Article 371D.
Correct.
The presidential order is no longer applicable to the state of Telangana. Presidential order is no longer applicable to the state of Telangana with effect from 2/6/2014.
Two
2014.
Yes. Then next.
Then the next third contention, but the respondents are relying upon a full bench judgment. Full bench judgment.
What full bench?
Full bench judgment. 2002, AR 2002, AP 115 is relating to interpretation of the rules pertaining to the presidential order of 2000, what is it? Presidential order 1974.
Therefore, of no
This judgment is no application. In respect of the students who are seeking the admission. MBBS course for the academic year 2022 and 23. But these are my subjects.
Oh.
So
now,
then I will deal with that.
now this our curiosity is over. You can now read at your leisure.
Yeah.
Then that's what we want from any. What are the submissions? Tell, then you can elaborate. You should see we are sitting here to hear you, not to interrupt. But we just have a curiosity.
Naturally.
Yes. So what is it? So now we are satisfied. Now you can elaborate.
Supreme Court defined your as a divine personality in Bhagavati Prasad case.
Oh.
In Salt Lake, allotment of plots. So all the judges in that, then naturally you have to hear, but you have to argue that.
Yes. No, the only thing, we are sorry to interrupt you only because to know what are your contentions. We have written down. Now you can go ahead in your own way. We will not say anything. Yes. Read the Supreme Court judgment, whatever way you proceed.
What I will read one of the synopsis. No.
Yes.
Shall I read, Madam?
Yes. No, this all we have noted down.
No, I am saying the synopsis I am reading.
Acha, that's it. All right.
The petitioner is a minor girl child represented by her father challenging the action of the respondent in declaring the petitioner as a non-local student in a provisional final merit list of MBBS admission. The petitioner families are from Telangana. The petitioner father is a permanent resident of Hyderabad. He was born in Mahbubnagar district. He is a native of Telangana. Petitioner was born in Hyderabad. The petitioner is also permanent resident of Telangana. Petitioner also studied in Hyderabad from class 1st to 10th. Both petitioner parents belong to All India Services. In 2017 and 2020, both the parents of the petitioner were transferred to Chennai in Tamil Nadu. Due to COVID in 2021, the petitioner being a minor girl and dependent on her parents had to accompany her parents out of compulsion. The option of boarding school in Hyderabad was not possible. All boarding schools were shut down during the COVID. The petitioner was compelled to study in 11th and 12th in Chennai. The petitioner along with her mother and father occasionally used to visit their houses in Hyderabad. The petitioner will not be treated as a local candidate even in Tamil Nadu. That is very much. The petitioner will not be treated as a local candidate even in Tamil Nadu. The short question which arises in this case, whether respondent number 2 in the facts of this case was justified in treating her as a non-local candidate. The petitioner's case is covered by law laid down by 3-judge bench of the Honorable Supreme Court in so-and-so 1989 3 SEC, which deals with the issue of local quota of children whose parents are employed by the All India Services. In Meenakshi case, the petitioner father was employed All India Services, IFS, and was transferred outside the country by Government of India. The petitioner had to complete her education for the qualifying examination outside Delhi, where her father was posted. However, Delhi University refused to treat her as a local candidate for an MBBS admission. The Honorable Supreme Court held that the qualifying condition of Delhi University that students should have studied at least 2 years of education in school in Delhi should be construed to mean to be not applicable to students or parents employed by All India Services who have to leave the country. The rules are in relevant paragraph and a relevant portion of the law judgment. Rules are intended to be reasonable and should take into account of the variety of circumstances in which those whom the rule seeking the government find themselves. This is the Lordship's opinion. We are of the opinion that the condition in the prescription of a qualification for admission into medical college in Delhi, providing that last 2 years of education should be in school in Delhi, should be construed as not applicable to students who have to leave India with their parents and the parent being posted to a foreign country by the government.
In that case, Nigeria.
Nigeria.
In your case, Chennai.
Chennai transferred, Chennai, All India Services. That is
So correct.
Place is different.
We are just telling you to convince you that we have read that judgment cited by you in Nafsi Malik's case.
Yes.
So that we know that her father was sent on deputation to Nigeria.
Yes, sir. No, but Supreme Court said, but it is not under Article 140. That is, but wherever the Supreme Court pronouncement was made.
Just a thought-provoking idea for you to respond. We will see. We don't know what Mr. Rao argues. We'll hear you. Yes.
Wherever the worship the emphasis to all, we are of the opinion the condition of prescription, but this indicates this is not under 142 but 141. But we are of the opinion that condition in the prescription of qualification admission to medical college, providing the last 2 years of education should be in school, should be construed as not applicable to the students who have to live in it. Then the paragraph, the Supreme Court judgment was followed in various support in All India Services. Children's parents, not that age, children's of parents who are in defense services were permitted to see admission as local candidate. Division bench of Bombay High Court in so and so and so and so. It should be children of state government employees were permitted to seek admission to local candidate, irrespective of candidates in so and so judgment, so and so. In case with similar facts of the division bench of Telangana High Court, considered a child of IPS officer, not this honorable court, who was transferred to Maharashtra for the last 4 years to be considered as a local candidate. But the other day I have cited the judgment of the division bench that was finally disposed of. This is Ramasubramanian and other lodge. And the paragraph 2. The university has not challenged said judgment before the division bench. Division bench judgment again final.
Where is that division bench?
Entry. But I have already passed the entry model.
Page 100.
The final order is by Lordship Justice.
The final order approves the entry order.
The final order approves the entry model.
Justice Ramchandra Rao. Page 100, Mr. Rao.
Yes, sir.
No, that is not. No, Justice Ramasubram. Not we have passed on it.
Where is that? Please give.
Yes, to you. But first I will take the entry order.
31.
For an entry order. But second page, the petitioner studied right from the first standard to the higher secondary only in the state of Telangana. But a brief period of 2 years, petitioner is the daughter of the officer belonging to All India Service. Due to the father getting posted in Maharashtra about 4 years ago,
Interim models proposition will have been made use of. I don't.
Your Lordship's reading the interim order and final.
Interim order is not a precedent. You have granted an interim order and you are arguing it finally. So there is no read of interim.
I'm saying,
What we are saying is that in compliance of the interim order, in that case, which you have given, the petitioner in that case was admitted and was process of completing first year. Therefore, a division bench of this court said that, I mean, in the aforesaid facts, no cause is made out for disturbing admission of the petitioner. You are not, we don't know, not completed first year as yet.
No, but that is the facts of this.
That case.
That fact. Therefore, madam, I request you.
Interim order reasons are recorded.
Yes, for interim orders, Your Lordship. Second page, the petitioner cited so and so, higher secondary so and so. Petitioner daughter is an officer belonging to All India Service. Due to her father getting posted in so and so place, the petitioner being a girl was taken for her father for mid study 9th standard, 10th standard in Mara. This is my reason.
Yes.
In cases of this nature, that is my emphasis. In case of this nature, residential qualification prescribed under the second part should be deemed to have been fulfilled. Should be deemed to have been fulfilled. After hearing this interim order that was again confirmed in a final. The final order, Your Lordship, say
Yes.
But I will read 2 lines from the final order.
Ah.
In the light of the aforesaid facts, but the facts were indicated, we are of the opinion no cause is made out for disturbing the admission of the petitioner pursuant to the aforesaid interim order, which has been acted and duly sets up justification thereof. That is justification thereof. And therefore, without proof, 89 Supreme Court was not cited, referred. The principle I followed in this case. Principle.
We
Then I
continue after the break.
Yes.
Come in the chamber for 5 minutes. We will dictate whatever is asked. Take this. Bring this. Only bring this. Bring this, and so that we dictate what our in this also.
My friend has filed memos in all the 4 cases showing that whoever has not been paid. But we are taking steps to see that all of them are paid, and I am filing replies to those memos. Kindly have it
No,
on.
he said that only out of
Only 9
nine.
were paid.
Only 9 have been paid, Mr.
Yes. But I'm submitting my reply to each one
So
of
what,
the
is
petitions.
there a remand matter? Is there a time bound direction to decide?
But there is no time bound.
The Telangana government gave an undertaking that they will
No,
not
no, no.
ask for a
Supreme Court, Honorable Supreme Court, is there a time bound matter?
expeditiously. 2 years have gone, that's all, 2021.
But it came before us probably once only.
That's the reason I'm not saying.
These people, I request senior counsel to be brief and concise. He says that he says that you are performing divine duties, you have to hear. So we are hearing him. Ask him to your senior friend to be concise so that we can hear you. It's not that for anything we can, it's a pleasure hearing him. We can continue hearing him till 4:30. No problem.
Medical college matters, I can't, because before 30th,
That's
your
right.
lordship wants to decide.
Yes. So therefore tell us.
After 2 weeks, by the reply,
Why he wants an adjournment, we have to record that.
But I am filing a reply.
Which is the last order sheet of that Supreme Court remand?
At that day, that another government pleader appeared and he said that
Somebody else, he was not there.
I was not there.
he was not. So they said that they have brought the 9 checks.
They was saying, yes. 9 checks have been handed over.
Yes, they have been handed over.
They have been handed over.
Mr. K.S. Murthy, learned senior counsel for the petitioner, submits that in compliance of the order dated 10/8/2023, 9 petitioners, checks to 9 petitioners have been handed over. Then what happened handed over on 14/8/2023
Yes.
by the revenue divisional officer Siddipet. And then what happened?
Now, the rest of the people, they said they are going to say
Exactly the complaint spirit. I have to report it by way of a reply to the memo. I am filing it in the register today. I have prepared it. I am filing it in the register.
Everybody else paid.
Everybody is entitled to we have paid. And
Only 9 paid, no? That's right.
No, these 9 paid. The others, I am giving the status.
When?
I have already filed it today.
Lordship, I have it at 4th minute, I'll come and.
Learned
on 4th, your lordship.
So and so submits that that the state government shall make payment to.
Shall file reply showing the status of the payment.
Acha, learned government advocate submits that the memos have been filed by learned senior counsel. You are at Tibeti, please mention. We will remember this. Yes. Otherwise, also it comes up this under altogether a different heading, so we know that it has to be given a priority.
Deeply obliged.
Do it, Mr. Don't seek an adjournment.
Yes. I am ready with the matter on that.
All right.
And I cannot mean that your lordship's divine personality without meaning any disrespect. I said your lordship's divine without any meaning.
No. We lighter when we say, Mr. Senior Counsel, at your age, you shouldn't take anything seriously, right? Except the point which you are arguing before us.
No. But what Supreme Court laid down that I have.
Yes, correct. We just, this thing,
Well, next thing, but
In lighter vein, we said, told him, he was also asking for 4th September in a lighter vein, that 30th August, it will all be over. Yes.
my experience,
It's a pleasure to hear, always a pleasure to hear the councils, and that's why we are judges. We have accepted this assignment of hearing people. So therefore, we can't, yes, go ahead.
it's well, it's similar. In Bombay High Court, but well, well, I wanted to shortcut the page in paragraph 4, well, well, before that, I wanted to show the rule, what was involved in the rule. At paragraph 6, well, paragraph 6. Paragraph 6. For 5, for 5-year integrated degree course. Rosh got it. Paragraph 6.
Meenakshi,
Which is in page here. This 11, it's right. Next. Well, paragraph 6, well, that a 5-year integrated degree course, LLB 5 years. Para 6, page number 8. A candidate passing SSC and HSC examination from recognized institution in Maharashtra state, or the candidate passing equivalent examination within brackets such as 11+1, a level of senior secondary school living certificate, bracket close, from the recognized board or oblique University of India, or outside or from the secondary board.
yes.
But this was the rule, insisting of the last 2 years, Maharashtra. So, but the facts of the case were to, then this is the rule where it was challenged.
No, which rule? Where, please read candidates from recognized.
Candidate from equivalent examination, such as 11+1, level of so and so, so and so. Maharashtra. Maharashtra.
Where is
in my last minute, which is in Maharashtra.
One second, read more.
Maharashtra.
Which is in March. This is this, which is in March. Senior security certificate. Working with another would have been obtained from a recognized university in Maharashtra. So the location.
But then I request you, the facts of the case. Few lines, paragraph, page 3, paragraph 4.
For a second, here for the 4 years. So, it's simply a consecutive years. Yes, the 3 parties complete. The residences, the government of people, the family who are appearing the place can be mentioned. Therefore, all the disability. Just 7 years, 4 years of sufficient out of 7 years, whichever they are receiving. Yes.
Paragraph 4, at page 3, petitioners are born in Maharashtra. Their parents are also born in Maharashtra. Paragraph 4.
Oh, yes.
The petition, but it is a son
Yes.
Chandrachud, not father Chandrachud.
Huh?
That's petitioner, well, I'm omitting two lines, but the petitioners are born in Maharashtra.
Yes.
Their parents are also born in Maharashtra. Their
Yes.
parents have property in Maharashtra.
Yes.
Petitioners not being considered from the state of Maharashtra only because they were compelled to attend 10th and 12th standards in Delhi. The father of the petitioner being in the office of the defense forces is deployed in various locations throughout the country. They had passed 10th and 12th standards at Delhi only on account of deployment of their fathers at various locations throughout the country. The petitioner cannot be deprived of equal opportunity of education in their parent state only on account of their father being an officer of the defense forces and being deployed various locations throughout the country. That is the submission. Then they dealt with the at page number 5, the Supreme Court judgment was cited.
That will be taken, Meenakshi.
Page number 4, unnumbered paragraph, Meenakshi Malik, and submit that apex court in the said case held that condition that the last 2 years education should be received in a school in Delhi should be considered as applicable to the students who were compelled to leave India as their parents being posted outside India by the government. Then that case was followed next case. Then I request Bharat to save your horse's time. The other cases also were cited similar nature, followed by Meenakshi Malik. Paragraph 19, number, page 21. Paragraph 19, page 21. The benefit of Maharashtra state quota is extended by an exception to the candidates whose father and mother is in Government of India service and transferred just prior to filling in the gap around by the candidate and the candidate was done only 10th and 12th standards from state of Maharashtra would be eligible to be considered for Maharashtra state. Though not domiciled in Maharashtra, and the candidates who are born in Maharashtra or whose parents are born in Maharashtra and domiciled in Maharashtra and are government employees, because that posting outside the state of Maharashtra, the candidate could not study his 10th and 12th standards from state of Maharashtra. He is precluded from taking admission from the Maharashtra state quota. The same would be unreasonable. Basically, Maharashtra state quota is to be provided for the persons domiciled born in the state of Maharashtra. The factual matrix in case Meenakshi Malik decided by the apex court, in case of so and so, similar facts of the present case. I will read this. Because they're being posting outside the state of Maharashtra, the candidate could not study his 10th and 12th standard from the state of Maharashtra. He is precluded from taking admission from the Maharashtra state quota. The same would be unreasonable. Basically, Maharashtra state quota provided not in so and so in the Meenakshi case. Last paragraph.
Study out, but still there.
Paragraph 21, right? Paragraph 21, my last paragraph.
We have read it.
Present case, the rules are challenged. In view of the aforesaid discussion, though we hold that rules are not ultra virus, however, we may attempt to add that same needs to be read down, provide relaxation or exemption of those candidates who are born in Maharashtra and whose parents are domiciled in Maharashtra, but due to fortuitous circumstances, such as the parent is in service of government and serving the nation due to service condition, is deployed in various parts of the country, could not complete their SSC or HSC from state of Maharashtra. But in this light of the above, respondent should consider the petitioner admitted in Maharashtra state. But by submission, but the other side, other cases was referred, followed by Meenakshi case, were also adverted in the judgment. But to save your lordship's time, well, I don't want to read all those judgments, but except this judgment is fair. Huh? Well, that your lordship said.
Which judgment?
But now I'm not citing any judgment.
This is only division bench. You are relying on this division bench.
This which said number of judgments which was cited by followed by the Meenakshi case were also adverted in this case.
Perhaps you can refer to in the rejoinder subject to what Mr. Rao argues.
That I'm not citing no more cases. Having to save the lordship's time, I only cited this case. That your lordship observed that in respect of the principle of 142, the 142 where the lordships were.
Let's see what he argues depending upon that.
No.
Please sit down. No, this is subject to what he argues. All right. So you say it's not 142.
This is not a 142. The Meenakshi case is not a precedent is not under 142. Is a precedent under 141. Wherever the Supreme Court to be treated as a 142, generally they said in a peculiar facts of the case, in the facts and circumstances of the present case, and the facts adverted in the judgment, we are granting this relief. Then we can say it is a 142. Sometimes, like Amtula Justice Ranganath Misra, he said, this we are giving a direction under 142, this cannot be a precedent. Categorically stated, the Constitution bench, 1988 Supreme Court Amtula's case. But I am giving illustration. So therefore, this case, Meenakshi Malli case, they said categorically, in our opinion, that was also followed subsequently by the others. Then coming to the case, on this case, wherever the person parents are all India service, they are in the government of India service, they are compelled to leave particular A place to B place. The transfer is condition, the incident of service. I cannot say no. And in the facts of the case, the petitioner studied from 1st to 10th Hyderabad. And there is a COVID situation. I cannot keep you in the hostels because hostels were closed on the COVID. But I have taken this child along with transfer place and studied, and whenever vacations are there, we got a permanent property house in Hyderabad where the father was the permanent brought up in Hyderabad. We have filed a certificate to that extent in the compilation. Therefore, the student who studied in Chennai, not the choice of the student in the complete circumstances, because of one way, parents were dislocated by transfer. B is a COVID situation. C, I cannot keep you any hostel because hostels were closed. These are special. Therefore, I am belongs to this state. Therefore, because of compelling circumstances, could not complete the +2 qualifying examination in the state of. Therefore, relief can be granted. So the relief.
Rahul. Rahul. You ask.
The relief may be granted on the circumstances to the petitioner. But the other thing, but they are relying on the rules, but I can.
Yes.
But I submitted 3 cases for granting the relief on the ground of the All India services with the students who belongs to children of All India service. One division bench judgment of this honorable court.
Yes.
Then there is Meenakshi Malik case.
First Meenakshi Malik, then division bench decision of this court, third is Bombay High Court.
The division bench judgment or High Court deemed to be, they said after hearing, they said the deemed to be. That was affirmed in a final disposal. So that has become final.
There was no adjudication of validity of rule.
There was not.
And the relief was granted. Why the proceedings were closed? Because pursuant to an interim order, the student was admitted and a student was admitted and first year prosecuted. It's not that case that you have been admitted and into first year. Supposing if we were to hear it next year in September, probably that will your case will be. Yes.
They're coming to this, my alternative submission.
Not come. He will come or not come? He told me that he'll come by 3 o'clock. Principle of reading down. Principle of reading down of provision. See the noise. Reading down, READING, reading down. When the court is dealing with provision, where the validity is challenged, right? So court's first endeavor should be to save it from unconstitutionality and to read down the provision. Read RE. Reading, you know what you read. Read down the provision. Get a case law on this. Then none of them is cited. Yes.
But I request for a paper book, page 18.
Paper book?
Page 18, rules.
18. Yes.
But these rules are framed.
Then you are second that not framed under presidential order. Yes.
But on the face of the reading of these rules for introductory part, but these rules are not framed under presidential order. These rules are framed partly on statutory basis. That is what you lordship kindly see the thing.
Act. Under section 3 read with section 15(1) of the act.
Right.
Not framed under this thing 371D. The preamble to the rule itself says that under Section 3 read with 15(1) of the Telangana Act. Correct?
Yes. And not under the presidential order,
No.
not under Article 371D. There is no reference. Either Article 371D, 323, or the presidential order 1970.
Okay.
But that I can say with my personal. Then I request you on page 20 of the same paper book. The relevant local candidate P. You have to deal with it. But the relevant now with an issue. The local candidate, a candidate admission shall be regarded as local candidate in relation to the local area. But this rules about part of the rules about the local area is not contemplated by this act, Telangana Educational Institution Act.
Local area is not contemplated.
Not contemplated under that act.
So this is a new argument that therefore this is a new argument.
Am I right?
This is a new argument. New argument.
But on the face of it, GO I'm reading. On the face of the GO, I'm making. But this local area.
So therefore, no, we have understood that local area is not contemplated by the act under which the rules have been framed. Therefore, rules are ultra vires.
No, I'm not saying. The state government is liberty to frame the rules in exercise of the executive power under Article 162. There is no law.
No, one this thing. You said local area not contemplated under the Parent Act. So right act.
The preamble of the act was cited that it was not contemplated the local area.
So then what happens?
The state government is a liberty, can exercise the power under executive power under 162. They can frame the rules. I had Article 162. But the settled law, Ram Javai.
Yes, sir. Ram Javai Kapoor. State of Punjab.
State of Punjab, 425 per year. This is Satyagraha. They are entitled to frame.
No, there is a provision here in the rule they have framed defined local area and all that.
Yes. But I'm saying this is not contemplate AP education, the Telangana education institution.
That we have understood. So what?
So therefore,
no. Therefore, what? Not contemplated under act. Then what?
This rules has to be read independently, without reference to the
that we have noted.
Presidential order.
That we have noted.
The candidate can be admitted. Your Lordship, I will see that. Number 21.
Rules have to be read independently without reference to presidential order.
Presidential order, Article 371D.
D.
Because
correct. Presidential order doesn't apply to state of Telangana with effect from 2/6/2014. And therefore, full bench decision of Andhra Pradesh High Court in 2002 has no application to the students seeking admission to MBBS course in 23-24.
Yes. Therefore, I request for your last kindly for a moment, Article 371.
Constitution, madam. Constitution of India. (371D). Yes. Special provision with respect to state of AP or state of Telangana.
Only 2 lines I will read. The president may, by order, made with respect to state of Andhra Pradesh or state of Telangana, provide having regard to the requirement of each state, equal opportunities and facilities for the people belong to different parts of the state. Then next, my lord, relevant rule B. Specify any part or parts of the state which shall be regarded in the local area. B, I am reading the 2B, local area. Then coming to the relevant local area. Then coming to the Roman 3, for the purpose of admission to any university within the state or any other educational institution which is subject to the control of state government. Then, to save your lordship's time, I will read rule 2. In the matter of admission to any such university or other educational institution referred to in subclass B, I may be specified in this behalf in the order to in favor of the candidates who have resided, that is my emphasis, who have resided or studied for any period. And under Article B, this is the
She will bring the immediately to the page. Yes.
The president may by order with respect to state of Andhra Pradesh or state of Telangana is to provide a presentation.
All right. Yes, please.
There is no presidential order. You can take
So you are reading something with 370D to B.
Three. Then 3. The matter of admission to any such university or other education institution referred in subclass B. I may be specified.
No, where are you reading? Please tell us so that we can.
I am reading Article 371 D.
Yeah, that we have already. Which clause?
That's it. B2. B2 Roman 2.
B2 for direct recruitment.
C Roman 2. The matter of admission to any such university or other educational institution referred to in subclass I may specified in this year or in the order. Who are in favor of candidates who have decided, that is my emphasis, who have decided or studied any period specified in the order, in the local area in respect to such cadre or
specifying the condition is not issued by PCL because it is not been issued with the order signature.
My submission is my submission.
Senior, one, as we understand 371D C2, your case is that the GO 144 that is issued specifying that condition of 2 years previous study is not issued under 371D, which actually is required to be issued under 371D with the presidential assent.
By submission, I will reframe my submission. Under amended 371D, Andhra Pradesh and Telangana was added with effect from 1/6/2014. Therefore, the president is obligated to issue a presidential order that specifying the area of the residency and study purpose of the admission to the educational institution. The president has not issued any order. This is the interest of educational institutions. My emphasis is very interest prescribing the residency or study, maximum residency or study.
Period of study is also not specified. Yes.
And
The
the
71D period.
present,
Anything with regard to this period to be only
Specified.
specified under 370. This GO is not issued in terms of this residential order.
but I am corrected my junior. President is not obligated, president may. Sometimes out of the respect, the draftsman may say, the president is the highest authority, he may say, may. Sometimes it should be mandatory. But it's a mandatory or not mandatory, I am not raising that issue. Only I am showing the relevant provision. So, there is no presidential order prescribing Telangana. The only presidential order is 1974 Good days. But that was the cause. State was divided for admissions and employment. That was the cause in the widespread state of Telangana. So therefore, my submission is, there is no presidential order prescribed. But notwithstanding there is no presidential order, state is not precluded to frame the rules. In exercise of the executive power, state frame the rules. They have a local area prescribing the conditions, study and conditions.
They can do it.
I am conceding.
You can frame the rules. You can exercise executive power under Article 162 and define whatever. This is what petitioner certifies.
I'm only saying
lighter vein, Mr. We understand all this. Lighter vein, we are saying what to do. All the time we can't be serious. We are not hanging anybody by neck right away. You argue with so much of seriousness. So we have to say something to bring a smile, right? On his face or our face. So that's why. The petitioner certifies that under Article 162, you can exercise executive power and prescribe local area.
So therefore, the purpose of my saying.
And local area will include Chennai also. Chennai is part of Hyderabad. By deeming fiction, you will say that.
Yes. Therefore, my submission is, the emphasis is, these rules can be read out independently without influencing any presidential orders.
All right.
If I come within the rule, but I should be advertised that the rule is to apply to me, alternative submission. But how these rules will come into?
What is now alternate submission?
Is not this, I submitted, this rules has to be independently read. Which is referring to the presidential order framed in 1974.
And you want a declaration that you are a local candidate, alternative prayer.
In terms of the rules, GOMS 411, I can be treated as a local candidate.
Which 411? What's confusing? Which he said 411?
411.
GO 114. GOMS number that 4114.
You said 400 something. I immediately got confused. What is, so I asked brother, what is 400?
By mistake,
Reverse, came reverse.
114.
114 is what?
GO, medical and education, medical.
No, correct. The rules you want declaration of you as local candidate. How?
That's what I'm saying. Take your kindly consideration. Page 20 minute.
20. 20.
Yes,
I am reading. But page 20, the bottom. Local candidate. A candidate for admission shall be regarded as a local candidate in relation to local area. A. If he has studied in educational institution in such local area for a period not less than for 4 consecutive academic years, ending with the academic year in which he appeared, or as the case may be, first appeared in the relevant qualifying examination. But in this case, the petitioner studied 10 years in Hyderabad, compelling circumstances 2 years in Chennai. That doesn't mean I did not belong to Telangana. The 2 years has to be exempted, has taken into consideration, has to be read down, taking into principle laid down in optional scheme.
That is correct. First submission is it should be struck down. Alternatively, it should be read down. So long as rule stands, you are not a local candidate. It is very clear.
This has to be read down. Can you the main option?
That's correct.
Then by the
While deciding the issue of constitutionality, only we will decide we will apply the principle of reading down.
Then seat.
No. So there is nothing like saying that I am, notwithstanding the fact that rule stands, I am still a local candidate or something.
Yes, but if the rules are independently read down, that I will.
If they are read down, correct?
Without referring to full bench judgment, without referring to the presidential order. That
Mr. You are relying on that Supreme Court judgment to say that it should be read down. Maharashtra judgment to say it should be read down.
Read down?
Right? So therefore, if it is read down, you get the relief. But as the rule stands, without reading down, you are not entitled to any relief. That is what we are saying.
I am coming to the rule, 2 Roman 2. B2. Same page 21. Roman 2.
If during whole or 7
may part of the 7 consecutive academic years, ending with the academic year in which he appeared, or in the case may be first appeared, but relevant to qualifying examination, he has not studied in the educational institution in any local area, but has resided in the state during the whole of the said period, 7 years, be regarded as a local candidate in relation to A. Such a local area.
1 minute. Give us one. But supposing if he appears for a second happen, that's why secretary of presiding
Well, I am reading A.
1 minute.
2A.
1 minute.
Yes, sir.
See, the second is no, so they're putting on same rule. But if he has not studied, he has resided in that local area. So second and joining these better say. Take it from next to but that goes should not be setting up. This is what is available. The key things is not 7 analytics. And I put on 4, they're going to 7. Same thing. The second year, you will transcript on the 7 years beside. Yes, sir. This is based on domicile. This is based on education. Okay.
But I read out Roman 2.
will hear this. 3:30 a.m. Reading down. Reading. Para. 15. See, these conditions have to be satisfied. So, like, TTC versus emergence of two symbols. See, this other that's why I said we would give them time. Since we if such instrument can be given without the electricity possible. Yes, we will establish the time by this is the female. That's when I get confused. I have described that. That makes it very situation here. Mr. Rao, this rule 3, what are the rules are in exercise of powers under article this thing 162 or it's a statutory force? No. No, 1 minute. No, 1 minute. Just we want. No, worry. No, 1 minute. No, we would 1 minute. We can wait on the preamble. See the rules. See, it is an exercise of powers under section 3115 Education Act. It's a statutory. Executive exercise of powers conferred under the act. They make the rules. It's a statutory. We got it. Statutory rules, mister, in exercise of powers framed under the act, correct? We just thought of. So this principle will apply. Interpretation in so you can see how it's been just with something. It's when it comes to DTC versus DTC, DTC versus Mazdoor Congress. Now, prepare the cases now. Forget about it.
But the what learned council has stated that
Huh? Yeah, forget about it. He's not said anything. You are yet to finish. You will have a right of rejoinder also, right? You go ahead with your argument. We just asked him. Hasn't said anything.
If I am not considered under rule B, CA as a local candidate 4 consecutive terms. If your lordship is not agreeing with me, Meenakshi Mallike.
Then this Supreme Court and Division Bench of Bombay High Court in your favor, you are relying that it should be read down.
Read down.
Correct. But as it is, the rule stands, you are not eligible. This is what we think prima facie, subject to what you argue.
Yes.
Correct? Because see, Mr. The requirement is of being having studied 4 consecutive academic years, ending with the academic year in which you appear for relevant qualifying examination.
Yes, sir.
Relevant qualifying examination is 12th.
Right.
Chennai is not part of Telangana.
Yes.
You passed 12th in Chennai, so you are not here in 4 consecutive academic years when you in the state of Telangana.
Yes, sir.
Therefore, you don't fall within that clause.
Yes, sir.
Other thing is requirement of resident is also not less than this thing 7 consecutive academic years
Yes, sir.
requirement. You are not residing here for last 2 years. You are in Chennai.
Yes,
So therefore we don't see that how you are saying that you should be.
In 7 minutes, I will come this word. I'm yet to complete on 6. Then if during the whole, I am Roman 12. If during the whole or may part of 7 consecutive academic, may
When will you conclude your submissions, Mr.? It's been almost 1 hour, 1.5 hours.
I'm the last leg of my submission. Your Roman 2. If during the whole or may part of 7 consecutive academic years, ending with the academic year in which he appeared or, as the case may be, must appear for relevant to qualifying examination. He has not studied in the educational institution in any local area, but has resided in the state during the whole of the set period of 7 years, be regarded as the local candidate in relation to such a local area. Chief Justice,
Now we are listening at all. Attention.
Such a local area.
We have read it.
Such a local area where he has resided maximum period out of the set period of 7 years. Then must be
such a So you say that do you fall under rule 2 Three,
Two,
rule
Three.
three,
two,
two,
C2,
B,
C,
C.
C2. Suppose 10 plus 2, 12 years. I am a resident. 7 years.
Yes, yes. 1 to 10 standard you have passed from Hyderabad.
Hyderabad.
So therefore you say that clause A is attracted and maximum period you have out of 12 years you have spent 10 years in Hyderabad. Therefore you should be treated as local candidate in relation to that area, local area that is Hyderabad.
Hyderabad. 2 years. Then this was discussed at a judgment reported 1976 AD. The only paragraph about this one. Even though I am studying in Chennai, I am a resident of Hyderabad. That I request you for the read of this paragraph. Yeah.
Para?
Paragraph 1,
Para 12.
12, paragraph 12.
Chambers Dictionary.
One line on the bottom of the marked area. Then I will read that paragraph very quickly. Chambers 20th dictionary gives the meaning.
This
The word research. Still I want to say, where is the to say, I will read Chambers 20th dictionary gives the meaning of the word reside as to dwell permanently, to be in residency, to abide, or to be vested in here. The concise Oxford dictionary gives the meaning of the word reside as have one's own, dwell permanently. The word reside brings out of the element of permanently in living a particular place. To say that if a young man or woman stays in a particular place temporarily, either on a visit or for short duration of study, he resided in that area and seems to reside in his own, which means the place where he has brought up, where his family lives, and where he gets back after the temporary work. He would be going against the normal meaning of the word reside. We therefore hold that the residence of candidate, though he has temporarily stayed in another area, even for purpose of study or training, where his parents or guardians of family reside in the local area in which he has applied admission to the university and where he has sense of belonging and where he gets back immediately after the short duration of study is his place of the residency. It follows
Mr.
that
One thing before reading paragraph 12 like this, you must point out that para 4b and clause 2 thereof was analogous to this perimeteria in this clause. This is an interpretation of para 4b or Andhra Pradesh Educational Institution Regulation of Admission Order 1974, which is not before us in this writ petition. You have challenged something else. So therefore, if you are relying on this, you must show that the provision is perimeteria. You should have first read paragraph 4b instead of para 12. This is all Supreme Court also, this Chambers Dictionary, everything. What is resident and domicile, all decided.
But analogous, I'm reading that I'm saying the analogous, even though 2 years I'm here.
Domicile has a sense of permanency where residence can be fleeting. This is the distinction. Right?
That I'm saying my case is I'm a resident of Hyderabad. Because of compulsion, I went there.
We are not saying that you didn't go out of compulsion.
COVID and my parents are outside. My parents are all in service. So therefore.
All right. We'll continue senior counsel tomorrow at 3:30. What can be done is, we thought that you will, this thing, 1 hour, 40 minutes, no signs of conclusion. We continue. Mr. Prabhakar Rao, can't be, what can't, we are doing our best. We would have concluded it today and written the judgment, no signs of conclusion. Ask him how much time, Mr. You must tell us today how much time will you take?
No, I have completed
Almost in reading.
Already your husband treated, I will give a reply that your husband treated my submissions are over.
Or,
They were,
so what is 76 Andhra Pradesh?
76 Andhra Pradesh.
No.
First time for the president, the presidential law 371D was brought in 1974. At that time, presidential order was issued in integrated state, Teetan state of Andhra Pradesh. At that time, Telangana is a part of the Andhra Pradesh state, Andhra state. There is a one state. Their interpretation came, the local candidate before this Andhra report, analogous to our rule. That was interpreted by the division bench. Merely are going 2 years outside the state by reading a paragraph 12.
4B. Where is para 4B of that, produce that residential order, whatever. Educational institution order 1974 para 4B. Because in the judgment it has not been referred to by division bench.
My paper book at page 97.
No. So you are saying that similar provision which just a minute. Let us try to understand, Mr. The problem is that we have to write judgment. So we should understand. So that's why we are trying to formulate for you. We are not formulating your submission. We are trying to say that your submission is, as we understand, your submission is that para 4B, this Andhra Pradesh Educational Institution Order 1974 is identical to the rule, and it has been interpreted by division bench of this court in 76 Andhra to mean that out of 10 years, if you have studied in Hyderabad and 2 years in Chennai, still you are resident of local area. This is the submission or not?
This is my submission.
Then, so got it right.
Page 97 of my paper book. Page 97 of my paper. That relevant provision I will just type. This is the presidential order.
No, we are asking about Andhra Pradesh Education Institution Regulation Order.
The same order. The same order. This is
Same order, right?
I am saying that the title is at page number
4B.
Page number 98, 96.
4B.
Relevant 4B. I am inviting you lots page 97. Local candidate 4B. Where during the 4 or any part of the 4 consecutive academic year, ending with academic year in which he appeared, or as the case may be, first appeared for the 11th qualifying examination. He has not studied in any education institution. If I resided in that local area for a period of not less than 4 years, immediately preceding the date of commencement of the relevant qualifying examination in which he appeared, or as the case may be, first year. For purpose of this threat, this is analogous to the provision, the present provision,
Which
framed by the rules of state law.
Rule 3.
Rule 2, the 2, Roman 2, Roman 3.
3.
C 7. This analogous answer. So therefore, the the whole issue, the entire, the state
Is covered by 76 Andhra Pradesh.
76, I am not saying, the 76, that particular paragraph, the residency was how they dealt by the lordships with reference to the presidential order and the presidential order of the state, the then state of Andhra Pradesh, but including state of Telangana. Merely, why I am purposely I am citing the paragraph. Merely I am living in Chennai. My home state is here. I satisfy 4 years of the local candidate. If that cannot be taken into consideration by your lordship, I will come to the 7 years. The I'm a resident of it. So therefore, the under the rules also, it can be taken into consideration without reference. That after the learned council makes submission, if anything, I will try.
That's it, Mr.
Yes.
Concluded, no?
It's concluded so far as my principal submissions and petitions are in a reply if necessary, I will.
Of course. I mean, we are only asking you about principal submissions only.
I am grateful to your lordship for hearing me.
No, the only constraint is the timeline fixed by. That's why. Otherwise, it's a pleasure to hear you, Mr. In any case. 1 minute. Will you give us 5 minutes that's all that?
Mr. Prabhakar.
No, then 1 minute. This person who had taken this, given a printout.
Somebody has to go to hospital.
No, the other, sorry, sir. Where from the start? All right. Paragraph, after this. Learned senior counsel for the recording is submitted. Learned senior counsel for the petitioner has also referred to order dated order has also placed reliance, not referred, replaced reliance on an order dated 12/9/2022 passed by Division Bench of Bombay High Court in Miss Priya Kedar Gokhale and another versus State of Maharashtra and others in support of and has contended that the rules need to be read down to provide relaxation or exemption for those candidates whose parents are members of All India Service. Full stop. It is also contended that decision of Honorable Supreme Court in Meenakshi Malik's case, Supra, has a that
Yes.
lest we may forget, we have recorded his submissions in 2 paragraphs,
Yes.
what all he has argued. So that we can deal.
Yes.
Now, how much time, Mr. Which case?
I'll just take, this is item number 27, my lord.
27.
27 and the
What is
synopsis with
WP
dates.
number?
My lord, this is WP number 21788 of 23.
217.
88.
21788 of
23.
Ah. So, Mr. So how much time will you take and who else for the petitioners? Nobody. Rest everybody is adopting. Adopting, no? Correct.
Item 31 is erroneously listed.
Erroneous. It's a commercial appeal. Because we remember that you appear in commercial appeals only. As soon as we saw, I told my brother that no commercial appeals today, the day is fixed for students. We'll come to it.
31 is erroneously listed. It got disposed of.
Disposed of.
Already disposed of.
That is 2018. His lordship, no, that's coming only for reference.
You, this thing, don't write 31. What we 31, don't write this common order in 31 and send it back. We have said so that it has already been disposed of despite that they are listing. Correct? Yes. No, let you first hear senior counsel, then decide whether you want to argue or not.
I may
How much time?
15 minutes at the max. And I'll
Max.
try to be as brief as possible.
Yes. Correct. That's
the state.
Beauty is in brevity.
Yes.
So we are more attentive all the times.
Yes.
So you have said 15 minutes, we'll be on an alert mode.
Yes.
With this thing that you won't repeat.
No, I won't.
WP number then 217558 dash 21788. Like we have said, no. His submissions in, so give side heading WP number so and so. This was item. And then now submission then WP number 21788 bar 2023. Oh, you have even given the name of hospital where you were born, right? Studied 11th and 12th from Royal.
Because in the case of being local, try to be as local as possible. As local. Born here.
Yes, born here. In that hospital also, yes. After completion of 11th. Oh, same thing, right?
But in this case, we don't reminder 4C, that 3C, 2, because we finished in 2022 and took 1 year break. And studied for
the petitioner has
Shall we dictate the facts from your synopsis? It will be easy, right?
The factual part.
So separate sheet for our reference. WP number, if you anything, please, at the end you can intervene.
Yes.
We are referring to your this thing.
Fact sheet.
217, 21788 bar 2023. The petitioner in this case claims to be the native of state of Telangana. The petitioner was born, it is averred in the petition that petitioner was born at so and so ADR hospital, Hyderabad, and passed his, Mummy Dallas, his, no. His schooling from class 1 Council clarified, he is also clarified. So then, madam, in these circumstances, delete, then learned senior counsel, delete. Learned senior counsel for the outset submitted that the so validity, learned senior counsel is covered
Yes.
extensively. Any addition to this proposition?
Well, what I'm trying to submit, because there are primarily three aspects before your lordship. One are these rules. If my lords were to see my papers, the rules begin from page 22. Those are the rules of GOMS 114 dated 5/7/2017, which is at page 22 of the material papers.
114.
My lord. This GOMS 114 allows the challenged rule position under 3 Roman numeral 3 B small a and b.
What page?
I'm sorry. That is at page 24 and 25.
If we can mark only in his or also rule itself, give it's better no for reference. Then again we have to come to your case.
Yes, please.
Rules are rules, whether from his case or your case.
Separate paper book.
No. So which
Same
rule?
page number, more or less. Same.
Okay.
Which rule is referring? So what is the rule under challenge, Mr.?
Yes, this rule under challenge.
Rule 3B,
3.
A and B.
Yes, rule 3.
Local
Roman
candidate.
numeral 3.
Same rule he has challenged. Same rule which he has challenged, right?
Yes, same rule which has.
Which in other petitions.
But same rule we have challenged. But what appears to be the case here and the problem which appears to arise from here is
Yes.
only this rule appears to form the basis of the university's regulations. Those regulations I have filed at page 52.
No, Mr. Then again we request senior counsel, please formulate your submission, then we will refer to everything.
Yes.
He has already argued.
Yes.
You have heard him.
Yes.
Now what additional submissions, 1, 2, 3, and then please elaborate.
Yes.
We will be with you. Go to regulation in, you said 15 minutes,
Yes.
right? So first submission is.
Going to submit, my lord.
First submission is.
First submission is that the rule 3, the challenged rule 3, Roman numeral 3B2, Roman numeral 3B A and B, small b, they only form the basis of the university's prospectus dated 3/8/23. What the university has not done is see what is immediately after this Roman large b, 3 Roman numeral 3b, that is C, which has formed the basis of your lordship's interim order, which says that 7 years prior to the competitive exam, if the majority of those
Yes. What it same case, sailing with the same boat. You are, Mr. Case is, no, you want to, we will formulate it for you.
And
1 minute, that you are submitting that I am a local candidate within this thing, rule 3B C 2A.
Yes.
I am a local candidate because majority of this thing
I
have spent in Hyderabad and only 2 years in whatever Kurnool.
Yes.
Kurnool or whatever, whichever place in Tamil Nadu.
Yes, my lord.
Right.
And one more thing where I may depart with great respect to the learned.
Challenge to rule first. What the additional ground or same ground?
The additional ground is this rule, these rules are undoubtedly made under the presidential order. It is not my case. They are not under the presidential order. Well, I do not know why they are saying so, because the presidential order.
Saying so, who is saying so?
The petitioners in the previous petitions. What I'm submitting, my lords, the rules are nothing but a cyclostyle copy of the presidential order. Even the presidential order provides.
No. So you mean to say that rules made under presidential order? Correct?
Yes, but once the presidential order rules are made, my lord, rules are made under that presidential order. Because even every word of that clause, my lord.
Mr. Rao is very happy.
No, what I'm.
You have made me smile, him smile.
I'll see whether he smiles at the end of the argument also, but but what I may submit, my lords, is if your lordship were to see the presidential order in my friend's vacate, which he has filed at.
We are hearing finally. So your submission is, Mr. Our senior counsel, we asked you, first submission is that you are entitled under rule 3C2A.
Yes, and this rule
Then 1 minute.
B2A is also founded in the presidential order.
And these rules have been made in exercise of powers under
the presidential order.
Under the presidential order.
371D. Yeah.
So rule has been made under Article 371D.
Yes.
Right. Then third submission.
So, my lords, if that is taken into account, the basis for calling me as a non-local by the university has only been by applying the prospectus regulation, which says that if for 4 consecutive years prior to the competitive exam, if you did not live in the state of Telangana, you become a non-local.
Right.
However, as had fallen from this bench in the interim order which was granted to me, one more submission is I just passed on the paper to your lordship, whereby pursuant to your lordship's interim order with regard to the petitioner,
you have been admitted.
I have been treated as a local by the university now. The university states so in its order, madam.
So their difficulties, they don't comply, then you say contempt. And if they comply, you use against them. It's all sub judice, right? So they are bound it. Mr. Rao has been more than fair to advise their clients to follow the interim order. So it has followed nothing. It is subject to the eventual order we will pass.
And one more lordship,
no argument.
Lordship has also directed them, and they agreed to declare the result. Till now, the result has not been declared.
We don't know, must be waiting for today's hearing. We don't know, we grantedly, but.
Saturday, my lords are directed.
Yes, that Mr. Rao will tell us. That's it.
Just one last submission, my lords. Great reliance in the vacate has been placed on the.
No, Mr. We are deciding it finally now.
My second point is the full bench order has not examined the scope of rule 3B2.
Obviously, it can't. 71. This thing 70 something 2002 full bench.
Yes.
And rule is 17. So how it could have considered?
In the presidential order, that particular clause is there. In the presidential order, that particular clause is there, but that.
No. So you are saying full bench does not apply, correct?
Full bench has only.
Same senior counsel said doesn't apply.
The full bench obviously applies in this case, but the portion of the full bench. Just let me elaborate.
No. See, therefore, what submission is full bench applies. He said doesn't apply.
Full bench, my lords, having not examined the scope of the 7-year principle, the 7-year rule, lordship FPC, page 56 and 57, it has not examined the 7-year principle which was already there in the presidential order. Having not examined the scope of.
So it doesn't apply.
It doesn't apply.
Same thing.
Yes, madam. Because if your lordship were to see the full bench order,
correct,
in my friend's vacate, which has been filed at page 56, 57, the relevant para I may read, page 40, para 45 of the full bench order. The full bench order only speaks about residence of 7 years continuously prior to the competitive exam. But that other clause in the presidential order, Manoj, of 7, the majority of those 7 years, which was already there in the presidential order, even at the time when the full bench order was written, Manoj, that has not been examined. That has fallen for consideration by your lordship's interim order, wherein your lordship say, I'll just read out that interim order. Manoj, the interim order is dated 11th August 2023. Just the second unnumbered para, your lordship may see.
Where is that interim order, madam?
May I submit?
We must be having the
Yes,
copy.
yes.
The original one rather. If we don't have, then something is wrong. Huh? Yes.
Lordship may see the second para, unnumbered para. Petitioner prima facie. Yes. Prima facie. What I'm trying to submit is the scope of this rule, Roman numeral 3 C(I)(2) was never examined by the full bench. If your lordship were to see their operative portion at page 56-57 of the wicket filed by them. So having not examined this particular rule, the 7-year majority rule, well, this full bench order will not come to the aid because
All right. Thank you.
well, the entire vacate, the whole construction of the vacate is based on this full bench order. They seek to oust the petitioners on the basis of the full bench order. So I thought some elaboration on this
Yes.
full bench is required, my lord.
Yes.
Therefore, my lords, my primary contention is this presidential order, that requirement of 7-year rule is there in the presidential order also. Lordship may see page 16 of the vacate papers.
Requirement of residence.
All I'm saying is this 7-year, the majority of those 7 years having lived in Telangana, my lord, that provision was already there at the time the full bench was considering it. That provision is founded in the vacate papers, which are at page 16, my lords. Page 16 for a moment, lordships may see.
No. We have this noted that requirement of resident of 7 years is was there in presidential order.
Also,
Then,
so it can't be the case.
So therefore, full bench applies.
No, full bench having not examined the scope of that particular.
This we have noted down, right?
Yes. Having not examined
the rule, we told you that it did not have examined because full bench 2002, rule 2017.
My lord.
Similar provision.
Similar provision at page 16 of
Not considered.
Not considered. Lordship may see that provision at
All right, got it. Similar provision.
page 16. At the bottom is that particular.
Got it, not considered.
Shall I read it?
Which clause of the presidential order?
Presidential order, page 16.
Clause.
Yes, my lord. 4(2)(I). 4(2)(I).
4(2), number 2I.
Yes, 2I. Local area.
4 within bracket 2 within bracket I.
I'll just read it.
Or it's 4.2.I.
4 in brackets 2 and in brackets I.
I. All.
1.
1.
Yes.
1 or 1. Correct. 1.
Yes.
This. Yes, correct. We have appreciated. Learned senior counsel for the petitioner submitted that full bench judgment of this court in so and so.
Roman numeral clause 4, clause 2.
Clause 2.
Clause 2, BI.
BI.
Yes.
Of the order
of
the presidential order. Therefore, the decision of full bench has no application to the facts of the case. It is further submitted that the petitioner is entitled to be considered as a local candidate under Rule 3, Roman capital 3 within bracket C within bracket small Roman 2 of the rules. Full stop. Yes. Next paragraph. Next writ petition. Who else? Which petition?
Item number 28.
28, madam, right? Which WP? Yeah.
Number 21926 of
21296 of
1926.
Whatever 96926, right out. You are adopting?
I'm adopting the,
1 minute. The petitioner is,
apart from the
facts, 1 minute. It's all being done for our benefit with separate paragraphs we write. So it is petitioner claims to be native of Telangana. The petitioner did her schooling from, as per the averments, as per the averments made in the petition, it is evident that the petitioner did her schooling from class 1 to class 8 and class 8th and 9th from Patna, Bihar, and intermediate in Telangana state. The after completion of the intermediate examination, when did you intermediate examination? When, Mr. 2021, right? 2021. After completion of intermediate examination, the petitioner appeared in NEET UG examination for the year 2023, and same thing, right? And the 2825/7, whatever. The petitioner was not treated as local candidate. Thereupon, this petition has been filed challenging rule. Which rule? Which rule you are challenging? Same rule, right? Rule
3B.
3B. No, delete. In this aforesaid factual background, the petitioner was not treated. No, you write petitioner was not treated as local candidate. Thereupon, the petitioners filed this petition. Paragraph. Learned counsel for the petitioner has submitted that the grievance of the petitioner is that the petitioner is confining the challenge only to validity of Rule 3, Roman 3, B, capital B.
Small a, and 3 capital C 1, Roman 1,
You are challenging that rule.
because it says something.
These people are relying on these rules. It's 3C1 of so and so. And under which rule you are entitled, Mr., to be treated as a local candidate?
Be entitled to.
It is further submitted that petitioner is entitled to be treated as local candidate under Rule 3
C1.
C1, small Roman 1.
If this word state is read as country, that's all. But the Rashtra kindly say,
In the word, this can't be submission. Should we write it? We cannot substitute the word used by a legislature. We have the power to strike it down.
I will be getting there.
No, but submission is to read what? Read what?
Rule says a candidate for admission into the course.
No, to read word as what? To read?
The word state.
To read word. Entitled to admission if the word used in Rule 3 so and so, you have written Rule
C1.
3C2.
C1.
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 1. If the expression state is used as country. That's it. Anything else?
Kindly see. I'll read the 2 paragraphs of the full bench judgment.
That they both of them have said doesn't apply. You give an extra ground doesn't apply.
I will read 1 or 2 paragraphs.
That's all reading. And who else? That's it. Mister. We will permit you to read. Which WP? Give.
Let the full bench judgment, your Lordship.
1 minute. We will permit you to. You are only reading full bench. We will also read facts we want to. Which WP, Mr.?
Item 32, my lordship. WP 22.
Which case you are, Mr.?
39.
32. 30. Don't come here. Item 30. 1 minute. 30. Madam, 30. WP number so and so. 30. WP number
22038.
22038.
Exactly.
So and so. The facts. Facts as can be. Just a minute. Who will write facts? We have to know. when we are writing in your presence for our benefit. Otherwise, what happens that at home we have to search the record to find out who is, when did he pass, which hospital you were born. All this will just now tell us that I was born in this hospital. Senior consulate sits with some hospital. Asa. Not said anything. The petition as what have you written? As can be deciphered from the averments made in the writ petition are. Don't keep it like this. We are reminded of Swami Vivekananda. We go to at once to state of Kerala. So that's why it's a distraction. So my can be about from the petition is that petitioner has studied till 10th from nursery till 10th in the state of Telangana and completed his intermediate from Bangalore in the state of Karnataka. Full stop. The petitioner appeared in the NEET examination so and so and has secured an all India rank of 232074 and that's all. The
When it becomes in 7 years, also 4 years.
Arey, Mister, 1 minute.
Your affidavit is silent where you have stayed from 21 to 23.
But he studied in Hyderabad long term, and has taken long.
There is nothing in the table what you have.
Yes.
Because if I apply, even we apply the rule 7 years also, you will be out. Nothing is there.
Let it not be.
Not.
He has taken long term, right?
Side within bracket you write, no ever mixing the representation.
With affidavit with regard to the period of
Find the gap certificate.
2021 to 23.
All right, bracket is. What is it, Mister?
My lord, item 41 and 42 I am adopting, my lord.
40. 40 is also there. 40 is also there. Included facts you will write, madam.
My lord, on 40.
40 you will write facts. Petitioner has so and so, and therefore nobody is appearing. You write prayer in the 40. You are there.
40, 41, 42, my lord. 41 and 42 I am adopting, my lord. I was about to say. 40 facts are little bit different, my lord. She is seeking shelter under the residency of her mother, my lord. She has studied abroad in 40. I don't know 40, but ordinary.
Where are the facts? Give us facts. 40. WP number so and so. The facts as can be gathered from. So this will be separate bunch, madam, tomorrow for Mr. Rao's argument. You arrange whatever numbers. The facts as can be gathered from the writ petition are that petitioner
Studied abroad, my lord. But qualifying exam is from here.
No. When from 10th to 12th, where
10 to 12 she has studied abroad. That is pleaded, my lord.
that petitioner has studied
12th is from here, my lord.
abroad up from class, has completed her education in classes 1 to 11th from abroad.
12th is
The
from here.
petitioner took admission in for 12th class
Yes.
examination.
Yes.
Plus 12th, what do you call 12th class? Intermediate examination in where had which Hyderabad, and has passed and has cleared the aforesaid examination. Petitioner appeared for NEET so and so and did not treat as local candidate. So that
Yes, ma'am.
you are not treated as local candidate.
Yes, ma'am.
So you have filed what challenging?
My lord, as such, I have not challenged a rule, my lord, in this petition. But I'm relying on the receipt. Ordinarily,
Just a minute. Just a minute. The learned counsel for the
That's residency.
Just a minute.
Yes.
One. Learned counsel for the petitioner submits that in the writ petition, the petitioner is seeking a direction to respondents number 2 and 3 to declare to treat the petitioner as a local shortlisted. They will of course come, but these petitions will come as a bunch tomorrow. Who else? Yes, that's it. Mr. Rao, if tomorrow 10:30, not possible, 2:30. How much time will you take? Oh, it's so brief. You have an answer in hand, it appears. Your smile tells us. Huh? So keep them under suspense. Oh, they will be under suspense tonight. All of them, what Mr. Rao is going to argue. You open your cards at 2:30, right? We'll take it up at 2:30. Type this and give a to PLN and he will carry you. I guess. Okay, aware of. Yes. So, order sheet you write, counsel for petitioners have concluded their submissions. However, on account of positive time, submissions of Mr. Prabhakar Rao Learned could not commence. List for further hearing tomorrow. What date? 22/8 remaining cases also come tomorrow.
Subject to your lordship time, 36 and 38 lordships, your lordships directed the practices.
Yes. What happened? Hey, what is the report? Good.
My lord, item number 29 will come.
Clean on this thing, right? All these are relevant. Otherwise lost. All this separately. 36. What happened? Seal cover. Array, you also don't know. So, WP 22172. Mr. Rao, if they are found to be eligible under the rules, they will be admitted, correct? Huh? Shall we say so? Shall we say so in the order subject to we don't know what is there?
Wait,
You don't have any stake.
yes, madam, as long as the rules are complied with, NMC will have.
Yes. But where is the final order in this thing? Karnataka case which I had passed. You have annexed, right?
That is 74 lordships.
Your case, visual, sit down. It will come up tomorrow, madam. So we understand your anxiety. You did not tell us that you come under cap category and you are arguing and second round of counseling has not yet commenced. Mr. Rao is telling us. So it can come up tomorrow. They have not declared the result as yet. You were worried what will happen. Nothing as Mr. Rao had. Why did you not declare? Oh, that's your prerogative. 30% of visual impairment. That means eligible?
No, not eligible. They are eligible for admission, but not under PWD.
Not eligible for the reservation.
PWD category.
Yes.
Yes.
There are two candidates.
Two candidates, both of them.
Kurva Siddhartha and Srujana. Both.
With detail, this thing. Gone, mister. What can we do? Yes. Mark the presence item number, same order in 36 and which case, mister?
38, madam.
30? 36 you first write, same order in 38. The petitioner is a person with disability, full stop. The petitioner had questioned the list prepared, list dated 1/8/2023 by which Yeah, this produce the report. You have said seal cover. The aforesaid report is taken on record. We have perused the report which is taken on record. Correct? All right. Remaining matters, this admission continue tomorrow. And this thing, person seeking enrollment with Bar Council, they also continue.
Milord, finally,
Let's
it's
see.
matter, Milord, at
Huh?
1:30. 1:30. Finally,
Final hearing will continue tomorrow.
oblige.